Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Let's start in Miami-Dade. Judge Mindy Glazer, a.k.a. Grumpy Pants. Let's see what's going on.
To the third degree. In count 3, there's probable cause for fraudulent use of a credit card. As to count 1, the court is going to grant the state's motion for pretrial detention, pending final hearing, and hold you with no bond. Count 2, the grand theft charge will be $2,500. In count 3, fraudulent use of a credit card is $2,500. You're going to see a judge tomorrow. The judge will set a final hearing on the state's motion for pretrial detention. Thank you for coming in, Detective.
Thank you, Your Honor.
Mr. Fleet, is you ready? Okay. Okay. There you go. Okay, Mr. Fleet, this is thank you. All right, page 1. All right, then we have some corrections. We're also going to need after him Eric Davis or somebody in court. Jesse Abreu Batista. I told my daughter, no good ever comes to go in a casino. Yeah, a casino after we. No good thing ever comes to go into a casino.
Your Honor, we have some other turns from other facilities also.
Yeah, I'll call those. Yeah, I can call that. Where did you correct the clerk? Who do you need out of turn? Just tell us.
I have number 61, 64, 65, and 66.
Thank you. We'll get those out of turn. Good morning. She's a Spanish interpreter. So we're here because you're charged with trafficking in cocaine, trafficking in crystal meth, and possession of a place for purposes of trafficking in a controlled substance.
Buenos días, estoy aquí porque estoy acusada de cocaína, de tenencia de un lugar, el propósito de traficar una sustancia regulada.
So your attorney, sir, Mr. Fleet, has anything you want to argue regarding probable cause?
No, Your Honor, no probable cause argument.
So, licenciado Pérez está presente en la sala, no argumento en contra del imputado.
However, Judge, if I may, as far as bond, I'd like the court to take into account that my client is a U.S. resident. She's a legal resident. She's been resident in Miami for over 15 years, has a home here, and is employed as an Uber driver. I don't believe she has any priors as well. I didn't see any, Judge.
Su señoría tenía que considerar para con la confianza que el cliente es residente legal de los Estados Unidos, que lleva más de 15 años trabajando aquí, que tiene su casa y que trabaja como chofer de Uber.
1 minute.
Un momento.
So they both sold to the CI. There's a search warrant. They find drugs, money, and a gun in the car, and then a trafficking amount of drugs in the house.
I'll find that there is probable cause for the charge of state. What do you want to put? $2,000 bond count 1 and 2? How long has she been here in the United States?
Ambos dieron al confidencial, además había drogas, no, y armas, y también en la casa había drogas. Bueno, se había buscado, y justo quieren la fiesta de la fiscalía, los buscan a cargo.
You sure when she entered the country?
I understand she's been here for 15 years, Judge, but I don't have anything.
Tengo entendido que más de 15 años.
I see addresses going back to at least 2012.
Okay. So is it okay? I'll set count 1 and 2 of first degree felonies. It's $15,000 bond count 1, $15,000 bond count 2, and $2,500 bond count 3.
Bien, entonces tiene esto. Desde el año 2012 puedo pegar de fianza, los cargos 1 y 2, $2 fianza cada uno, $2,500.
Thank you. Have a
We're
good
also
day.
requesting a Nebia, Judge.
What? There might be a Nebia for that amount.
It's over state's objection.
Oh, no. Next, we have Kenny Rodriguez Suarez. Page 8.
coming up.
Spanish interpreter, please. Good morning, sir. You were arrested for trafficking in cocaine, trafficking in crystal meth,
Buenos días, arrestado por tráfico de cocaína, tráfico de metanfetamina y cristal,
armed possession with intent to sell cocaine, crystal meth. I'm sorry, that's wrong. Possession of a what's count? Armed possession with intent to sell a controlled substance.
encargos de experiencia o intención de venta de una sustancia regular.
Use of a firearm during the commission of a felony,
Uso de un arma de fuego durante la comisión de un delito mayor
and possession of a place for purposes of trafficking in a controlled substance.
y tenencia de un lugar con el propósito de traficar una sustancia regular.
All right, your attorney is present. Can you please state your name?
Good morning, Honor. Carlos Fleites on behalf of Mr. Rodriguez Suarez. Buena, Kenny.
Su presente en la sala y sus reglas.
Do you have any argument regarding probable cause?
Judge, yes, it's probable cause. In reading the A form, it appears that prior to the execution of the search warrant, there was a traffic stop leading to part of the charges, the armed charges, the possession with intent charges. We would postulate there was no reason for that stop. None is in the A form. It was prior to the execution of the warrant, so that there is no probable cause for those charges. As to the search warrant charges, we don't have a probable cause right now.
Bien, entonces, el argumento cuanto al motivo portado es, según el informe de arresto, la búsqueda se debe a previamente los detuvieron en una parada en el tránsito. Y
So Judge, I don't have a copy of the search warrant, but it likely includes vehicles as well.
el área, me parece que tenían razón suficiente, por lo que no hay nada.
What'd you say, Ms. F?
So I don't have a copy of the search warrant, but it likely includes vehicles at the residence as well.
No tengo copia de la orden de cateo, debe vehículos en la casa conmigo.
It wasn't at the residence. He was stopped on a
But
traffic.
the car was initially at the house.
There's probable cause for all the charges.
Hay motivos para que no tomen una posición.
Count one, trafficking in cocaine, it's 60-something grams. State, what do you want? You want a $25,000 bond on that?
Yes.
$25,000 bond, count one.
Yo, $25,000 fianza por el cobro.
Count two, trafficking in the crystal meth. What do you want on that one?
Christine?
$25,000.
Yes.
$25,000 bond, count two.
Número dos,
Count three, armed possession with intent to sell a controlled substance is $7,500.
tenencia sustancia regular, de venta, o
$7,500.
$7,500.
Count four, use of a firearm during the commission of a felony. $2,500 bond.
Por tenencia de un arma de fuego, comisión de un delito, para la fianza.
And count three, possession of a place for purposes of trafficking in a controlled substance is $2,500.
Tenencia de arte en el propósito, tráfico de sustancias reguladas, $200.
Did you want a Nevia?
Yes.
Okay, plus a Nevia requirement. You have to show the money used to post your bond is from a legitimate source of funds.
Además, el requisito de negro tiene que probar que lo que usa para poner la fianza viene de
You have a good lawyer, listen to what he tells you. Thank you, Mr. Freitas.
tiene un buen abogado.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Judge Glazer continues to struggle with her audio quality. Whatever changes they made in her courtroom, they were 100% the wrong choices. Let's thank you, Ellie, for pushing that button for me. Let's go to Wade Mercer.
Hello, Your Honor.
Ms. Monroe, good morning. Ms. Monroe, you're here. Your mother's in the courtroom, by the way. You're here because you've been accused of one count of battery on a person 65 years of age or older. Ms. Monroe, there is probable cause for the charge. Ma'am, I looked at your criminal history and I went and read the file from last year, your arrest. I think your mother was the victim in that one. So I'm
Yes,
somewhat
sir.
familiar with that. I think that's about all you have. But
Yes,
let me
sir.
see what the attorney's position is, ma'am. Then I'm going to address your bond status. Mr. Mitchell, anything?
Nothing at this time.
Mr. McDaniel?
Your Honor, I know at this point in time, she probably doesn't have any place to live, but we'd ask the court maybe to consider a cash bond. The mother plans on getting her out when she finds her a place to live at, someplace to stay. It probably is not going to happen today, Ms. Monroe, but she does want to get you out and someplace else stable.
Mr. Mitchell?
Okay,
what's
I
your
do have a
position?
place to
Don't-
live at
don't-
my father's house.
Don't. It's all right, Ms. Monroe, don't talk.
Just a second. We'll see if you have any questions. Mr. Mitchell, what's your position on the cash bond?
No objection to a cash bond.
So for third-degree felony, I'm going to set you a $500 cash-only bond, Miss Monroe. Miss Monroe, if that home is verified, I know that we tried this once before. We went to your father's house for a few days. If that's verified, I don't care where you live as long as it's not with your grandmother. You can have no contact with your grandmother, who's the alleged victim. So you can't go there. It's got to be somewhere other than there. And your mother's going to work on that, and someone's going to talk to your father and see if that's an option. But you're not going back to that residence, at least not in the immediate future. You're not. So you've got a $500 cash bond. You're entitled to use the phone in just a few minutes, ma'am, but your mother's in the courtroom, so she knows about the bond. And I think the goal is to talk to your father and see what his thoughts are. Miss Monroe, do you have any questions?
So I'll be released this week and I need to take my meds. I'm on meds and I feel like I might be pregnant also.
Well, that's a lot. You got a lot going on then. So yes, there is a condition of your bond to take your medication as directed by your physician. That's a condition of your bond. As far as other health concerns or when your family will post the bond, I don't know. I think that I want to speak for your mother. So ma'am, is the plan to post a bond for her once you find somewhere for her to live, a safe place? So your mother's shaking her head, yes. So if your father is willing to let you live there or somewhere else, then your mother's going to post a bond for you, but she needs to get that place to live before she does it. Right now, she's not spoke to your father. Okay.
And what if my father's plan doesn't work? He doesn't want me to live there. Could I live with my brother's at a house in Mariana?
As long as you have a lawful place to live and have no contact with your grandmother, that's the important thing. Is you got to have a place to live that's safe. And your mother's not going to post a bond for you, hopefully, until you have a safe place to go. Okay. I'm going to ask the jail to give you a notice for your court date. When will that be, Dawn? November 4th at 8:30 will be your court date before Judge Garcia, ma'am, and I do wish you the best.
Okay, thank you.
Yes, ma'am. Ma'am, I didn't ask you. Did you have any questions? I'm sorry. All right, thank you. Trey Anderson. Mr. Anderson, good morning. Mr. Anderson, you're here for 2 charges. The jail sheet is wrong, Corporal. It says attempted burglary, but the warrant and the complaint are for attempted robbery, not attempted burglary. So you're charged with 1 count of attempted robbery and 1 count of felony battery. Mr. Anderson, there is probable cause for both charges. I've also looked at your criminal history, so I'm somewhat familiar with that. It's a long criminal history. I know that you've been to prison at least twice. Mr. Anderson, I think you're entitled to a bond as far as I can tell, so I'm going to listen to the attorneys before I make a final bond decision. Mr. Mitchell, anything?
Just a moment, Your Honor. Let me double check something.
I don't have anything, Your Honor. He was just put on probation last week in Tallahassee.
Yeah,
Been in jail for a while.
nothing at this time, Your Honor.
Mr. McDaniel?
Nothing, Your Honor.
Mr. Anderson, I'm going to set your bond at $10,000 in each case because of your criminal history. You've got a condition to have no contact with the alleged victim and no contact with that business where this supposedly happened. Let me see if it was Dollar General or if it was Family Dollar. It was one of those top stores. Let me look at the complaint again. You may not even know the alleged victim. I have no idea, but no contact with that person that's accused you of this. And Mr. Anderson, no contact with Family Dollar, no contact with any Family Dollar while this case is pending. Mr. Anderson, do you have any questions?
No.
All right. Wish you the best, sir. But we also need to give Mr. Anderson a notice for that same court date, please.
Yes, sir.
Kaviana Herring. Ms. Herring, good morning. You're here because you've been accused of 1 count of child abuse without great bodily harm. And then you have a hold out of Bay County. The Bay County hold has a bond on it of $2,500. The Jackson County charge, there is probable cause for that charge. And Ms. Herring, I think you're entitled to a bond. Let me see what the information the attorneys have before I set that bond. Mr. Mitchell, anything?
You said she's out on bond in Bay County?
No, she has a hold for Bay County.
She has a hold for Bay County.
Yeah, and it's a driving offense.
Driving license suspended.
So it's just a warrant. It's not a bond case.
Yeah, nothing at this time.
$2,500 bond on it.
Anything else, Mr. McDaniel?
Nothing else, Your Honor.
So, Ms. Herring, based upon you having pending charges elsewhere, your bond's going to be $10,000 cash or surety. You have a condition of absolutely no contact with the alleged victim. The complaint kind of lists 2 victims, but they only charge her with 1 count. So the person you can have no contact with is a 17-year-old male. That's the alleged victim of the child abuse. There's also a reference to a choking, but that was somebody different, and the law enforcement officer didn't charge you with that for whatever reason. But you've got the right to use the phone in a few minutes and try to post the bond. The judge will give you a notice for your court date. Say November 4th.
Yeah.
November 4th at 8:30 will be your court date. And just stay away from that person if you do post bond. Even if you don't post bond, no contact with that person. Do you have any questions?
No, sir.
Have a good day. Adam Lurch. Mr. Lurch, good morning. Mr. Lurch, you're here because I first appeared to you and I held you 7 days. I believe you were on bond out of Calhoun County for a crime of a battery or some type of charge involving the same alleged victim. There was a condition of no contact, and then you got the following cyber stalking and harassing here. So I held you 7 days. Where'd that come from? So you got to cut that off. Okay, you may want to wait outside till we get to your case in, because I got to have court here. Okay. Mr. Lurch, I asked Mr. Mitchell to notify the state attorney's office or the authorities in Calhoun County. I looked this morning. I didn't see anything where they had filed anything. So, Mr. Mitchell, any updates from Calhoun County?
I spoke with our Calhoun County office today. They said that there's sort of a tentative agreement where, if he did go back to Chrome and, completed Chrome, they would not revoke his bond over there. But like if he went back and he left Chrome, then they would file the motion to revoke. So they were just saying, see if you could let him, I guess, as part of his condition, his bond condition.
Yeah, okay, I see what you're saying. Go ahead. I'm sorry, I interrupt you.
Yeah, as a part of his bond condition for him to go in and complete Chrome. And if he does that and he completes the program, they won't revoke his bond.
So you heard what I've heard then, Mr. Lurch. Calhoun County it is what it is. Mr. McDaniel, anything on behalf of Mr. Lurch?
Your Honor, I know that he, they've allegedly sent some text messages that are very threatening, and I don't think he's, trying to downplay those things. He did voluntarily go to Chrome, and he did voluntarily come over and turn himself in after he found out about this warrant. And I don't think he has really any criminal history except maybe a traffic offense, in the past. And I'm not trying to downplay it by any means. I know it is a serious things that he said, that allegedly said in those text messages, but we'd ask the court to, maybe consider letting him go to Chrome, because I think that's probably what he needs is some therapy.
All right, so Mr. Lurch, if you want to go to Chrome, that's entirely up to you, but I'm certainly not going to give you a conditional release when you threaten to kill somebody. Or basically, I think that what I read in here was the text message she said came from you, said something about, I'll make sure our child has no parents. Something to that effect. So there's no way I'm going to give you a conditional release with those kind of allegations and that kind of evidence against you, especially when a judge had ordered you to have no contact with her. So if you post bond, you've got the right to do that. And you've also got the right to voluntarily go to Chrome, but that's the only way you're going to get there from me. So you've got the bond I set for you. You've got the right to post it, and we'll see what Calhoun County does. But right now, it's like they're not doing anything. Mr. Lurch, do you have any questions?
No, if I could just go ahead and start, am I allowed to go to Chrome or?
If you post bond, you can go to Chrome. If you don't post bond, you're going to be in jail until your case is over.
How much time am I looking at if I just go ahead and plea out today?
You can't plea out today because it's actually you could, but I think no offer was made at first appearance because I wanted to give the time for the state to interview the alleged victim before an offer was made, and that's been a week. Has that had a chance to do that?
Not yet.
Okay. So when do we want to bring him back so we can see him, Mr. McDaniel, if he doesn't post bond?
I mean, jail arraignment date, which is going to be about a month from now. And I think it'd be best if he just sits there some. And then, I'm going to work on getting you back over to Chrome, Mr. Lurch, but I think they're going to want you to do a little bit of jail time. So just hang tight.
What is the jail arraignment date, just so he'll know? So November 12th is the next jail arraignment date. So unless Mr. McDaniel brings you up before then, that'll be your court date if you don't post bond. If you do post bond, you'll have a different date because that date I just gave you is an in custody date. Any other questions, Mr. Lurch?
No, sir.
Have a good day, sir. So Corporal, I had a couple of other packets, but I think they were both immigration packets. So,
Yes,
I'm
Your
just gonna
Honor,
send
they're
those to the
both a
clerk's
hold
office.
for ICE.
So John, do y'all open files if there's no local charges? So what do y'all do with those packets? Yeah, I'm not sure why y'all get them. Because there's nothing local, there's nothing in Jackson County at all. So what do y'all do with them? So do y'all need them? So Corporal, if it's an immigration only case with no Jackson County charges, the Jackson County Clerk's Office isn't going to open a file. So there's really no point even sending those up to us because they don't need them. We don't need them. Now, if they have local charges, it may be helpful. Defense wants to see them and state wants to know that. But like these two today, if it's strictly an immigration issue, it's just like a federal case, another type of federal law case, or somebody y'all were holding for the U.S. magistrate or whoever. It's none of our business. But Corporal, I think that's it on what we have for first appearances. Let me see if I missed anything. Anything else you're aware of, Corporal Drown?
No, Your Honor.
Mr. Mitchell, anything else from the state?
Not at this time, Your Honor.
Mr. McDaniel? No, Your Honor. Please.
All right, since he's finishing up, let's go to Texas. We'll say good morning to Judge Stevens.
Briscoe.
Okay, 25 CR 883 is called the State of Texas versus Alex Briscoe. You are Alex Briscoe.
Yes.
You were present with your attorney, Mr. Adams. You've been indicted with the second-degree felony of aggravated assault, which carries with it up to 20 years in prison if found guilty. But it doesn't end there. You have a prior conviction out of Harris County in 2019 for being a felon in possession of a firearm. If all of this is true, it bumps your punishment range to a first-degree felony, which means you're looking at no less than 5 nor more than life imprisonment on this case. If it were me, I'd consider it real important. What are you doing today?
Just move it to the announcement. This is initial appearance. But I have given him this indictment in police before.
Do I?
Said I have given him his indictment and the probable cause application. He has all that.
All right. The state, who is on this one, please? It looks like Mr. Laird.
Yes.
What is his bond here, please? You've already been convicted of 2 other felonies. Then you got a felon in possession of a firearm conviction in 19. Then here, I'm looking at the facts on this case, and there was a firearm used in this case. What's his bond?
Yeah.
Okay. I want you.
$35,000.
You're going to have you're at home confinement. I don't want you leaving your home. And you have to have a GPS device so I know where you are at all times. You understand? You don't like it? You don't like it? Tough. You are a danger. This is the 3rd time you've messed with a felony. And you think it's other people's fault? You're going to be at home confinement. Do you work somewhere?
No, sir.
You don't? Well, okay. Then you don't have to be going to work. Who lives with you at the house?
My kids.
Mm-hmm. Well, who supports the family?
My girl.
Who does? Your wife?
I just got back.
What, your wife supports the family?
Yes, sir, but
What does she do for a living?
She worked. I just came back.
What does she do for a living, sir?
She's a general manager, so I just lost my job.
Okay. Well, you can go out and look for jobs, but you've got to stay on home confinement. You can go find a job and you have to go to and from the job location in the most direct route. I got a lot of people who are on the same type of conditions and they are doing just fine and making a living. So don't say you can't do it unless you don't want to. But that's your condition. You are dangerous. I'm looking at the circumstances on this case. I don't want you ambling about without me making sure I know where you are at all times. You understand, sir?
So did you?
You've got 48 hours to get that done. All right.
Can I ask you something? You said it's three of them.
You have a conviction of being a felon in possession of a firearm in 2019, which means you had a felony
No, sir,
before that.
I was with somebody else, sir. It was two guns in the car.
Wait.
They took out running. So
A felon in possession of a firearm.
Yes, sir.
That means you had to have had a felony. I mean, that's.
You did a jury trial on the felon in possession and got a guilty verdict. And they sentenced him 2 years.
Okay. He wasn't eligible for probation. That means you got a felony conviction.
Yeah, he's got state jail.
A state jail. Okay. What were you trying to tell me? That wasn't right at all, what you just told me.
No,
And you
sir,
know
that's-
more about your life than
That's
you
what-
have you have a state jail felony conviction. That's a felony.
Sir, I was already a felon. I was already a felon, but the guy who I was with that took out running, that's what made it a felon in possession of a firearm.
I'm sorry,
because
the
it was
jury
two
thought
guns.
otherwise. They convicted.
Yes, sir. It was beat at first, but it was dead out, but they came back.
The jury, well, we have to follow the jury's verdict unless you appealed it and you didn't. And now we've got this situation. But you can go to and from work, to and from to get food, and to and from church. And we need to know where you are at all times, though, because I don't want you ambling about because you misuse firearms. What do you want to do next?
Just announcement, Judge.
Okay. 4 weeks. Good.
Yes, sir.
Thank you. Please get a reset. Thank you. Serenity Mays. God bless you. Serenity Mays.
That's Miss Mays.
That's you? You're in 25 CR 967. You're charged with the third degree felony of forgery.
Yes, sir.
And that means you're looking at no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 can be assessed. So it's serious.
No, the probation officer.
Okay. Today, what do you want to do?
Yes.
Just, this is our first announcement, Judge. Just put it on announcement. And
4 weeks gonna be good or 5? Is that good? Okay.
you know,
All right. Thank you. Please get it resetting. Renisha, are these all initials? Renisha Owens.
Bird.
Renisha Owens, please.
I'll send it.
In cause number
Just- just give me this
25
for the rest of the day.
1035, Renisha Owens. There is no answer.
TCF, come on up.
You gotta move quick. We got a lot to do.
If you do defer restitution, I won't give a fine. I'll cut this fine.
You gonna send it? I mean,
Okay, you're Renisha Owens.
Yes.
You're charged with the second degree felony of burglary of a habitation, which means you are looking at no less than 2 no more than 20 years confinement in prison, and a fine to $10,000 can be assessed. You understand what you're charged with in the penalty range here?
Yes.
And Mr. Adams is your attorney. It's an initial. What do you want to do?
just announcement.
Okay. Okay. 4 weeks good.
That's what
You're resetting
And Judge,
and
so,
follow his advice.
and Judge, on that deal, tomorrow I have it at 9:30. He's in TDC, so it's nothing.
Okay.
Yeah, he's in TDC jail.
Okay.
And I verified that with Miss Larry.
Okay. How would she? Who's?
Lacey verified.
How does she know?
I asked her.
Oh, she saw him there, I guess.
I-
Jacorin White,
DC roster.
you're at Jacorin White, 25 CR 115A.
Yeah. Is that it?
Come on in. Jacorin is wearing white today. What's the deal? I didn't get the memo on this. I'm underdressed.
Looks good.
Everybody else? I mean, well, it's nice that you feel this is important because it is.
It is.
You were charged here, sir. Hold on. You're Jacorin White, right? And you are charged here in 25 CR 1158 with the second degree felony of assault on a peace officer. Where'd he go? John, where's your attorney?
Oh, he has, John West texted me this morning. And he said that he's stuck in another court, but he's asking for resetting for an announcement.
Okay. When's he going to be here? In this court? And which court is more important? I'd like to know. There's not a higher felony court than this one. I don't understand.
He's in another county judge.
Okay.
But
Did you know he wasn't going to be here? Have you met him before, sir? Okay. Well, let's just go over this so that you know just where you stand on things. And I don't want you to, you can ask me a question, but you don't need to answer on any of this. I just want to make sure you understand fully, since this is what we call an initial appearance. This is the first time you've been here. So initial appearances, what we do is make sure that the defendants understand fully what they're charged with and a little bit about the nature of the case and what the potential punishment range is. In this second degree felony of assault on a peace officer, you are looking at, if convicted, no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Serious. Have you ever been charged with anything before? Never. Okay. Well, I was inside of my let's well, Mr. West is a good attorney, and just follow his advice. I'm going to reset this for 4 weeks since he's not here. This next event will be what we call an announcement. You will hopefully have discussed all this with him and then decided where y'all are going to be headed on the disposition of this. Okay. Get a resetting from that lady. Thank you. Mr. Stevens. Markham Champagne, Mr. Champagne,
I'm gonna give you the.
23 CR 705.
So I'm here with the highlighted access one. And we'll give you a copy, okay?
Come on out. Are you Markham Joseph Champagne? Yes, sir. You're charged with the state jail felony of forgery. Okay. You know what it's about? No, sir, I do not. It's looks like a check. It's written in the amount of $4,900, purporting to be the act of another person on their check, and apparently, according to the authorities,
is that to do good credit?
It is.
Okay, I'm already currently on probation for that.
Who is?
I am at Jasper County. I have paid all the money back. It's all said and done. As far as there were checks wrote here,
Yeah, well, every time you write a check,
yes,
in every location, that's a crime in a different jurisdiction. You have to clean up all the messes.
yes, sir.
This is well,
got receipts.
no, this is something that was done here in Beaumont.
Your Honor, I believe there's 2 written here and 1 in Jasper. I can contact the Jasper office to see what the restitution amount is in that case and see if it covers the amounts written here as well.
Make restitution.
For what, for which check? For all the checks?
Yes, sir.
Okay. Well, what's odd about this is, have you been moving around or anything?
I just recently moved, Your Honor, from Winnie to Bronson, Texas.
To where?
Bronson, Texas.
Okay. See, this indictment is very old
Yes, sir.
and which is anything unusual catches my attention
Right.
because things work in a certain way in coordination. Generally, within weeks or a few months of indictment, the defendant comes in for their initial appearances, not
Year
27 months later.
Yes, I understand.
So this was indicted in June of 23.
Yes,
and it states that you committed the state jail felony of forgery here in Jefferson County, Texas. And
I spoke with a detective about it.
yeah,
And
he didn't, but
I asked the detective if something is done over this to please notify me. I will turn myself in.
Okay.
And that's exactly what I've done.
All right. Well, it's come to light.
Yes, sir.
And you just need to just deal with it in a responsible way. And
Yes, sir.
it ought to
What
work
I'm
out.
trying to do now. I turned myself in on the
This says it's a check in the amount of $4,900 that went to Do Good Federal Credit Union at 1795 North Major Drive.
Yes, sir.
And it was,
like I said,
and it was returned back, not authorized counterfeit check. So that then gets it. Gets investigated by the Beaumont Police Department, and they file a report dated January of 23.
Yes.
So that's going on 3 years almost.
I wish I'd have known it had.
Well, it's sometimes things don't get out, and
Yes.
and if you. This shows your address, 521 McDermott Winnie. When was the last time you had that address?
6 months ago.
Okay. Well, I don't know why it didn't work its way to find you earlier, but you got to just deal with it here.
Yes,
And
sir.
it's something that can be worked out. It's not a crime of violence.
Yes, sir.
And is there a loss of $4,900 to this bank, or did they stop the check somehow?
Your Honor, I believe there's two cases. They're both checks. One is for $4,000, one's for $4,900 here in Middleton. And to my knowledge, there is a loss of that amount. He is correct that there was another check case in Jasper. I don't know if the Jasper case collected all the restitution. That's something I would have to call and find out. It's all to Do Good Credit Union, just different branches.
There is a second indictment, 23 CR 706,
Yes, sir.
that was also handed up by the grand jury on June 21st, 2023. And it states that on October 27th, which would have been the day after the other indictment date of an event, on October 27th, 2022, you passed forged financial instrument to the victim, which was in this case. I do that again, the same bank. Yeah. You wrote another check for $4,000. So you got a $4,900 check on one day, and then a $4,000 check on the next day. You understand? Okay, so you got two indictments, and they're both state jail felonies, which carry with it up to 2 years in the state jail. They're convicted on each case. So what are you doing about a lawyer?
Not have one, sir.
Okay. You're unable to hire one?
Yes, sir.
You need to fill out one of the indigent forms. We're going to give you that, fill it out, then come back and swear that it's all true and correct. Don't make any false statements.
Yes, sir.
And if I
My life up, sir.
deem if all is well, then you will have an attorney appointed to help you, okay?
Just sit over there and fill it out and come back to me when you're done. Judge, you did not call this person. It was on the first page.
Inland Falk,
Sir.
Finland.
Sir, behind the wall.
25 CR 123. That's you, Mr. Falk? Okay, this is initial appearance as well. You're charged here with second degree felony of aggravated assault with a deadly weapon, but it's not good. You've been here before, right? Have you been here on this case at all before, or is this the first time? You got 2 convictions, robberies in 2002 out of the 252nd District Court next door. After that was final. This says you committed the felony of illegal possession of a controlled substance and were convicted in the court next door in 2019. Thereafter that conviction, it is alleged here in this new indictment that you committed the second degree felony of aggravated assault. This would be generally a second degree felony punishment of no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000.
Yeah.
But because you had those 3 priors and 2 of them on one day in 2002, the third one is years later, but those are never in the past. They can always be used against you. You are looking at habitual felon status. If convicted of all of this, you're looking at no less than 25 years in prison, nor more than life. It's about as serious as it gets. Are you getting a lawyer? Are you able to get a lawyer?
At the moment, I'm probably gonna have a job.
I'm sorry?
I have a job.
Okay,
Just
where
do
do
it
you,
at the moment you can, Judge.
where do you work? How much are you making an hour? 34? All right. Well, that's a fortune for a lot of people. How much time do you need to go talk to some people to hire? You got 4 weeks, okay? And then come back, see where we are on this. You're in a minefield. You gotta be careful walking through it. You don't want something to blow up. Because these are big explosions, 25 to life. See if you can fix that. Get with a lawyer as soon as possible. If you're unable to, come back. We'll take care of things. Thank you. Emmanuel Flores. Emmanuel Flores, please. 25 CR 1116, Emmanuel Flores. There is no answer in the courtroom. I ask the bailiff to call into the hall for Emmanuel Flores, please. What is his bond?
$5,000 cash bond.
There's no response, Your Honor.
No response to the name called here in the courtroom. No response to the name Emmanuel Flores called into the hall by the bailiff. Defendant has failed to appear. A warrant was issued for his arrest. Did you say it's 5,000?
5,000. It's 5,000 cash is what he posted.
His cash bond is revoked. It is doubled to $10,000 for failure to appear. Plus, he must have a GPS device. So we know where he is when he's not in court when he's supposed to be.
All right, let's change it up a little bit. Let's go to Michigan and spend a little time with one Judge J. Cedric Simpson, whoever he is. Never heard of him before.
Does not believe a conflict exists between this partner office, but if one were to arise, we would waive such a conflict.
Court, for its part, also does not believe that there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Jennifer Wallace.
Ashley Vogus for the people.
I have not spoken with my public defender before this. Is there a way I can speak with?
That is true. Assistant Public Defender Lauren Parody on behalf of Ms. Wallach. Ms. Wallach, I've applied to come meet with you, but I have to be approved by the facility. So my paperwork is in, I just have not been approved yet.
Okay.
So, Your Honor.
I'm due to be released on the case I'm sitting on in 3 days on Saturday morning.
In 3 days?
Yes, sir.
Fantastic.
So I was hoping for possibly a PR on this and another court date so I can talk with the public defender.
I concur, Judge.
She could have done this herself.
I know, I think so.
All right.
I'm sorry. Thank you.
No, it's okay. You got it. You're good.
I'll just ask you, Ms. Wallach, when you get out, call the public defender's office and update your contact information.
Okay, no problem.
All right, I'll adjourn your matter to November 5th, 2025, 9 a.m. or as your invite indicates, bond will be reset. Hearing no objection to a personal recognizance $1,000 bond. Thank you, ma'am.
Thank you. Have a nice day.
Court does call the case, People versus Mohammed Dayan.
An Assistant Public Defender, Natalie Pate, with and on behalf of Mohammed Janet, who is present. There he is. Sir, can you please state your name?
Mohammed Janet.
So, Your Honor, I'm asking an adjournment for 2 reasons. Similar to the last situation, my paperwork has been in and my approval has been pending for a little over a month to visit with Mr. Jan at the facility. I did reach back out to them this week to ask for an update as to that goes. I was provided with a phone number to speak to Mr. Jan this morning, which I did call and was able to speak to a front desk person who did transfer me. That phone number then rang for 2 minutes and then disconnected. So I was unable to actually speak with my client as well this morning, sir. So I do apologize for that. I made every attempt I could. I know his out date is some years out, so I'm just asking for an adjournment.
I would like to address may I address the courts real quick, please?
You are. Go ahead.
I was just gonna say, I haven't spoken to my lawyer since my last adjournment on August 6th, and I was just trying to say, I'm at this facility now, so if y'all don't have the addresses, they can give it to you. I never got no mail, and I wanted to be able to talk to my lawyer in the breakout room because I don't want to adjourn it.
Well, I'm not going to give you a breakout room. Your counsel just explained everything to the court. I'm going to adjourn it to November 5th, 2025, 9 a.m. She's trying to get in touch with you at the facility.
I want to
All right?
request for a speed trial. Can I say that on record?
Okay, that will be considered. I'll wait for the written motion.
Thank you, Your Honor.
Thank you.
Sir, we'll be in touch.
Court does call the case, People versus Lawrence Peck.
Asphalt for the people.
Your Honor, Joe Simon on behalf of Mr. Peck making his way to the podium. State your name, Larry.
Lawrence Peck.
All right.
Your Honor, we have 2 reasons to be here today. One is the violation and the court's amended order. Before we get to that, I will tell you that Mr. Peck, as you may remember, was being screened for acceptance into the 15th District Court Sobriety Court. He is going to enter that court. There's a little bit of transition with the probation agent in that court. There's a new one coming in and Ms. Johns is retiring. But we hope to resolve this case and his PCC before you on the 23rd in combination to effectuate that revamp.
Okay.
So I think what Ms. Feltus and I talked about is adjourning this pretrial till November 5th, which would probably be moot anyway after the 23rd.
Got a correct statement.
That is, Your Honor, there's a pending attempt, resisting or obstructing that arises out of the same incident, so.
Well, I'll adjourn the pretrial and bond violation to November 5th, 2025, 9 a.m.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Thank you.
Okay, from outside. Okay.
Court calls the case, People versus Michael Heed.
Asphalt for the people.
An arraignment.
Yes.
Thomas Heed, for the defendant who's approaching, Your Honor.
Your name, sir?
Michael Keed.
What's the relationship?
He is my older brother.
Okay, I'm welcome. All right.
We're here for an arraignment and pretrial,
Yes.
Your Honor.
As to the arraignment, you waive formal reading, stand mute.
Yes, Your Honor, we do.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea on his behalf. All right, where do we want to go from here?
Your Honor, we are, of course, as the court stated here for the agreement, if you think they're recall correctly, we had discussed adjourning this case to see if we could work it out short of.
Yes. Will November 5th be a good date for you?
I'm here all the time.
Okay. Yes, November 5th will be a fine date, Your Honor.
We'll adjourn this then to November 5th, 2025. 9 a.m. As to bond in this case, I will set his bond at $5,000 personal recognizance bond, standard conditions, including no assault to behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
I do, Your Honor.
Is there any reason that for you the no-go to is going to be a bit of a difficulty only because you live on Clark Road.
I do, Your Honor.
So what I'll do is you're not to go to or enter the Clark Road address, the 40.
Your Honor, he lives there.
I just said that.
Okay.
If you let me finish.
Okay.
I'm going to say apartment 313.
Okay.
All right. Thank you. Was there a no contact that you wanted or no?
Yes, Your Honor.
All right. With,
It's on the bond.
is it?
Erica Hogan.
I'm sorry.
Erica Hogan, ERIKAHOGAN.
We have that on the mount one. Put it on this side. They did. Can you put that on this one? No contact with Eric. And not to enter. I need the address for this apartment 350. All right. Okay.
Thank you.
Thank you. Court does call the case People versus, is it Sudhil Singh?
Special Office for the People.
Good morning, Your Honor. Joseph Wagner on behalf of Mr. Singh, who was, state your name.
Sukhdal Singh.
Your Honor, we're here for two reasons today. One is an arraignment, and we waived the reading. And I'd ask you enter a plea of not guilty for my client. And we understand there's a pretrial that I've spoken to the prosecutor, and we've agreed to adjourn it until the 5th of November.
And having waived formal reading. This is, my stickers are all out of order, folks. Defendant having waived formal reading. Asking that a not guilty plea be entered on letter that not guilty plea. Pretrial in this matter will be adjourned to November 5th, 2025, 9 a.m. The bond in this case, bond will be set at a $5,000 personal recognizance bond. Order standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or illegal drugs. I will also indicate at this time he's not to enter any Sam's Club in the state of Michigan. All right. Thank you.
Thank you, Your Honor.
All right, let's change it up a little bit and go down to Texas and see Judge Boyd. But pay attention to who's zoomed in at the bottom, ADA Morrison. Take a look at his face. He's got a story to tell. Something's happened to him. I don't know if he's related to this case or not, or if he's just waiting for something to be called, but take a look.
006123, State versus Christina Lozano. Can I have parties announced?
Hunter Morris for the state.
And George Manning for the defense, Your Honor.
And are you Christina Lozano?
Yes.
All right, we're here today for sentencing. You entered a plea to count 1, paragraph A. The court found that there was sufficient evidence to find you guilty. I'm assuming there is no application for deferred adjudication. Is that correct?
Well, if I believe we should have submitted one, Judge, because really the agreement would be state is opposing deferred, but recommending probation, and that's basically the impasse if there is one.
All right, did you want a PSI or are you waiving PSI and I will hear argument?
There was a PSI done, Your Honor.
Let me
So I
see.
reviewed it.
I don't
yesterday.
have a copy of the PSI. Just one moment. All right. Okay. Thank you so much. All right. Have both parties reviewed the PSI?
The state has with no objections, Judge.
And I did as well, Your Honor. No objections. or
Right, and
amendments.
you all are correct. I remember now receiving and reviewing this PSI because that's where we got the amount that's due. So are there any witnesses from the state?
And none from the state, Judge. And in full candor, I believe the state was silent on the defendant's application.
That is true. Any witnesses?
No witnesses, Your Honor.
All right, then the court will hear your argument for deferred.
Well, Your Honor, after reviewing the PSI, I can say with full confidence that Ms. Lozano did admit guilt. She knows morally what she did was wrong. She took accountability. There weren't statements in there like this didn't happen. It wasn't that big of a deal. She has been in therapy. She has PTSD, depression. She was sexually abused as a child. She does have a fiance that's in Mexico that she would like to move here. Can't be here because of immigration issues. But taking it back to the offense, Judge, she knows that just because she was going through financial difficulty, that doesn't justify her actions. And what I would like to say is to take nothing away from the victim impact statement. However, 2 of the victims were less than 30. And while one of the victims, yes, Ms. Finland is technically elderly, it may not be targeting an elderly individual in the same sense as, maybe cases where somebody works at a nursing home and takes somebody out of somebody's purse or something to that effect. There were other victims as well, and they weren't elderly individuals, but going on, Judge, she did pay restitution as well, start paying to the detective on behalf of the Thomases, which shows that she knew what she did was wrong. She's trying to make it better. And in the statement from the Thomases, they said they believed, that she deserved a second chance, maybe depending on her criminal history. That's what Mr. Thomas had said. Of course, from the PSI, it's evident that she has no criminal history other than these charges. So this isn't a repeat compulsive sort of problem, Your Honor. I know what someone of your stature, someone in charge of a district court may be looking at these sorts of offenses and thinking, is this a compulsive pattern where somebody is constantly targeting elderly individuals and committing crimes of moral turpitude? But it's never happened before. I believe firmly, after representing Ms. Lozano and talking to her, coaching her through this case, it will never happen again. She knows it's very serious and she will never want to be in this position again. From the victim impact statement from Ms. Finland, I didn't really understand if it seemed like she talked a lot about thinking community service of some sort was appropriate. But I can't really articulate it. It didn't really say anything specific as far as if she thought some sort of deferred was appropriate or anything of that nature. So I can leave the state to decide that, but it did say several things about different suggestions for community service. like gift wrapping at Christmas and working with animals or something to that effect. So again, Your Honor, in the future, she knows that this should never happen again, and she is looking at future career options such as continuing as a medical assistant or perhaps trying to get her nurse's license, being an LVN, RN, taking that route. So I believe, Your Honor, that she does deserve deferred. As you know, there are a lot of consequences on deferred. It's not an easy road. She can be adjudicated guilty. She can become a convicted felon and have crimes of moral turpitude on her record. She can face a jail sanction for up to 180 days. She can face TDC, more importantly. So because of the consequences, Your Honor, and because deferred also gives the court room to punish her if anything does happen again, or if she's not compliant with probation, I'd ask the court to place my client on deferred adjudication and give her a second chance to make this right, and perhaps in the future avoid becoming a convicted felon.
All right, is there anything you wish to say? No. All right, well, I have some questions. Any objections to the court asking questions?
No, Your Honor.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Christina Malala.
All right, so I've read the PSI report, and in the PSI report, when you're asked questions about using these cards, you say you don't remember. What is that about?
I mean, I remember using the cards. I think it was more just kind of in general, like kind of how the day went. Even though I know I committed a crime, I mean, it still is something that weighs on me every day. Never been in trouble. I don't do things like this. And so that's kind of where I didn't remember. It wasn't that I didn't remember necessarily committing the crime.
No, it says the defendant was asked about the details in the offense report, stating that she used the card to pay for her rent, but stated once more that she did not remember. This officer then pressed her recollection and encouraged her to be honest, and she reported that she did use the card multiple times. She reported that she attempted to pay her rent first, but was adamant that all transactions were unsuccessful. She was asked about her financial situation at that time, and she stated that she was struggling financially and had to pay for rent, car payment, insurance, and was not managing her money correctly. The defendant was asked about the purchase with the Randolph Brooks card at Amazon and Cash App, and stated that she doesn't remember the transactions, but they must have happened. So I'm trying to figure out, how are you unable to remember that you made transactions on these cards? Because your statement in here says that you only remember attempting to pay your rent and it didn't go through, and that you're adamant that all transactions were unsuccessful.
Yeah, so I remember clearly that it was for my rent. I don't, when she mentioned about the other charges, I was not aware that I made those charges. I mean, I possibly could have, but I remember being used for the rent because that's what was the most important at that time that I needed.
But I mean, it said that the payment for the rent was unsuccessful.
Correct. Yeah, I didn't.
So you don't remember using it for other things?
I do not.
This Amazon and Cash App? So why do you think it would be okay to take someone else's cards to pay for your rent?
It's not correct. It was.
But I mean, you did it. So why did you think that was the route to go?
Because I thought it was an easy way, and I realized very quickly that that was not correct. And it doesn't matter what situation I'm in.
So when did you realize that that wasn't correct? So you had the unsuccessful, according to you, you attempted to pay your rent. It was unsuccessful. So did you remember at that time?
At that time, I was like, this is wrong, and I threw it away because I thought
All right,
that was
so you're saying it was wrong, but then after that, there's an Amazon purchase and there's Cash App purchase. So what do you mean you realized it was wrong, but according to this, you continued to use it?
Like I said, I definitely do not recall using it on Amazon. I can't remember this moment what I even would have used it for in that moment. I do 100% remember using it for my rent, and I just felt super awful in made me feel so bad because I was like, oh my God, like, what is that person going through? That, you know, my issue, I could have figured out a different way. And that's how I felt in that moment. I
And
don't,
why did you stop paying? Because it appears that, who knows, I'm not with the police department or with the DA's office, but it appears that you were making payments and then you ended up ghosting that person and stopping making payments. Why?
so I was making the payments and then I unfortunately had to get a new phone because I was in financial issues. So I had to get a new number. And when I had called the police department where me and the detective had met, I couldn't get a hold of him. I had tried calling 4 different times. I couldn't remember his name. But I had the receipts of what I had paid and I was trying to ask like, hey, can someone get me in contact with the person I was speaking with? And I was just never able to get in.
Did you go to the police station?
I didn't.
Why not? That's the best way to find this person if you truly want to make amends.
Right.
So why didn't you?
It just wasn't something that crossed my mind.
And then you said that the reason why you're in these difficulties was because you were not managing your money appropriately. What do you mean by that?
I just wasn't budgeting correctly and I had a car payment that was just way too expensive and I wasn't able to afford and rent at the same time. And I needed to be responsible and get rid of that car.
And why didn't you get rid of that car?
I think it was just my not wanting to see, like, just not wanting my family to realize that I wasn't making it. I think that was just kind of the biggest thing.
Do you still have that car? So when did you get rid of that car?
I believe it was like a month after this incident.
Mhm.
I gave it back to the bank that I had it with.
So I'm trying to make a decision on whether or not to give you deferred. What I can tell you is people on probation in this court, I don't allow them to work with vulnerable people. So you're not going to be in the home healthcare field where you're dealing with patients. You're not allowed to work with minors. Do you understand that?
Yes.
So this is me trying to figure out whether or not to give you deferred. And this is my question for you. With your stealing of those credit cards and using them, what do you think the person whose cards they belong to, what do you think they had to do to straighten all of that out?
Go to their banks, make phone calls. I mean, I don't know, it's definitely a long process. I've had the same situation happen to me and it's a very, very difficult process. And something.
So no, I mean, what process? I'm
Having to call your bank and, verify those charges and have them like go through like the fraud process. And then having to get those cards reinstated back to you, which can take 7, I think, to 10 business days for them to come in the mail.
And then what do you think happens if they have money in their bank account and they have bills that are coming monthly out of that account and those bills are not getting paid because you stole it and you are using money? So maybe they think they have, $6,500 there, and that $6,500 is there because that's where their mortgage comes from, their car payment, their utilities, and now everything is bouncing. I don't know, do they still call it bouncing? That's what we called it when a check would bounce or it would bounce and everything is bouncing. And what you're failing to realize is that when you have a bank account, and maybe if you have a check that bounces, you know what ends up happening?
They charge you.
Now, your bank charges you the overdraft fee. And then now they do it where whatever account was trying to get that money, they charge you a fee. So for the person who has their utilities coming out of their account, they're probably not checking it. They're thinking, oh, everything is fine. Maybe they come home and their utilities are off. And then you know what? It's a snowball effect because then they have to call the utility company searching why they don't have their money. And then guess what? Then pay the utility company extra because they're going to pay you a fee to turn your electricity back on, right? So that's extra. And then you have to pay them because your check bounced. And then you have to pay the bank because you had an overdraft. And even when people have overdraft protections, there's a fee associated with that. It's just not like the bank saying, oh, we're giving you free overdraft protection. So I don't know if you're internalizing everything. And if you're telling me that in the past you've had this happen to you before, I don't know if you're I don't know if you should get deferred adjudication counsel.
Well, Judge, I mean, she has taken a plea. I can tell you without violating any lawyer-client confidentiality, she's never been the type of client to lack accountability and tell me this is just all bogus. It never happened this way. They're lying. There's none of that. we discussed this case and she came to a decision very quickly. And I know she realizes the impact of her actions. I will say with respect to credit card fraud, every bank is a little bit different. It happened to me a few months ago, or maybe about 5 weeks ago. Have USAA within about 5 days, it was all cleared up.
I mean, I understand that, but somebody is paying for it, right? Even if the bank says, hey, we realize that this was fraud and it's not you, and we're going to put that money back in your account. They're not just putting that money back in the account and saying, oh, well, that money that they're putting back in the account, trust me, they're passing it along to their customers some kind of way, even though they probably have insurance for fraud. So it's not just, oh, we're not hurting anybody by doing this.
No, and I agree. I mean, I understand that my actions were very wrong. And that would never happen again. And I do feel very sorry for the victim because like I said, I have been in that situation and it's not something that's easy at all.
Were you in that situation before or after this happened?
Before.
So I don't know if you're sympathetic or not because you wouldn't have done this. And sometimes when people are having financial hardships, if you just ask for help, usually people will help you. But you can't work in any offices or anything because you can't be trusted in an office. And that's just based upon this. And you can't work around any money. I'm not going to allow it. And that's based upon this. So are you currently employed? So how are you supporting yourself?
I had got fired for this case and I took out my 401k and that's kind of what I've been using.
So here's my question. And I always say taking out 401k, usually people do that a lot. Why didn't you just take money out of your 401k when you were struggling with car payments and everything instead of stealing?
At that time I was transferring jobs, so I didn't have I had only been at my job for 6 months and then I had transitioned to a different job, so I didn't have a 401k like anything available.
But now that you're unemployed, you have a 401k.
Because I had been with my company for the last 2 years before this case.
All right, anything else?
Again, Your Honor, she has, I believe, from the PSI taken accountability, though she wasn't totally clear on the details. That doesn't mean she contradicted any of the events or she's here saying this didn't happen. She's pled to all of it. She's making an effort at restitution. She already has paid in the past. I'll reiterate that deferred isn't an easy road, and there are so many ways that the court could come back and teach her a lesson if she were to violate, including prison.
All right. Well, this is what I'm going to tell you. This is a crime of moral turpitude, and whether you have deferred or a conviction, it's always going to be a crime of moral turpitude, and it's going to be on your record. And anything that requires you to have a license, this is going to pop up, and you may be precluded from having license. That goes for cosmetology, whatever business that requires you to have a license, this is going to pop up. You understand? All right, the court will sentence you to 8 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month for 6 months. There's a remaining restitution to Lauren Thomas of $875. There's to be restitution to Randolph Brooks Federal Credit Union in the amount of $36.74.
And Judge,
Yes.
I don't mean to interrupt, but for restitution, after reading Ms. Finland's statement and talking with defense, can we bring the fine down to $750 and add $250 in restitution to Ms. Finland for the cash missing from the wallet?
Defense?
Yes, that's what we had agreed upon, Judge, because that wasn't accounted for.
Okay. So then that's a remaining balance of $1,125?
That'd be correct.
All right. So the remaining restitution to Ms. Thomas is $1,125. And then restitution to Randolph Brooks Federal Credit Union in the amount of $36.74. There's to be no contact with Deborah Finland and Lauren Thomas. The MRT course. 150 hours of community service restitution. You'll have to do those hours at an approved restitution center. Probation will let you know which places are approved. If there is something that you're interested in, let them know and we'll see if there's an approved place for that. Usually it's the San Antonio Food Bank, but if there's a shelter and you want to do it at the shelter, you can do it at the shelter. All right. And Ms. Abrams, when I say shelter, I mean the animal shelter. All right, and then there's $1,000 fine, and that will be probated. And the state will take in consideration CC 734399. Probation, is there anything else? You had mentioned that your client was suffering PTSD.
Yes, Your Honor, she's personally, she uses telehealth therapy services right now for counseling.
All right. Rashawn, can you, out of custody, can you do a, have her evaluated for MIC? Okay. Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, and this is what my grandmother would always tell me, my mom tells me, and this just goes through our family. And the number one thing is you cannot build your happiness off somebody else's misery. So even if you think it's a shortcut for you, you need to ask yourself, am I making somebody else's life miserable? And if the answer is yes, don't do it. Now, you're on deferred adjudication. If you successfully complete it, you won't have a conviction on your record. However, this is always going to be on your record. And anytime you try to apply for a license, it's best that you be truthful with them up front, because you know what's going to end up happening. If you say no, they're going to end up, you may end up getting the job, but then when that background check comes through, they're going to see this and usually they will fire you. Do you understand? The other thing about deferred adjudication, if you don't successfully complete it, you're looking at potentially 20 years in the prison. You understand?
Yes.
And this court communication is key. If there's an issue, you need to let your probation officer know about it. If you feel that they're not addressing it, you can always come back to court, but do not ghost them. You understand? All right, good luck to you. Is there a impact statement or no?
Just real quick, just for restitution clarification, my understanding is that Ms. Lozano paid $825 today,
Yes.
by today, for the Thomases, so she owes $875 to the Thomases. My understanding is she also paid Randolph Brooks, and so it would just be the $870 and then $250 to Miss Finland.
No, I thought you all were adding $250 to the $875 because she paid $825. And you all told me that the balance was in the beginning was $1,700. And so then that left the $875. And I thought you all were adding $250 to $875.
So we are adding $250, Judge, but not to the Thomases. That's to go to Miss Finland, who's the individual that wrote the letter.
All right, just 1 second. We're back on the record. So there is a restitution to Lauren Thomas of $875. That's the balance. And then you say that Randolph Brooks has been paid?
That's my understanding, Judge.
All right, then there's no restitution to Randolph Brooks. And then Finland, what is the first name?
Deborah, Judge.
All right, so then to Deborah Finland, there's to be restitution of $250.
Yes, ma'am, that's correct.
All right, so that the record is clear, the amounts that are owed are $875 to Lauren Thomas and $250 to Deborah Finland. The restitution to Randolph Brooks Federal Credit Union has been paid in full.
That's correct.
All right, thank you. Thank you.
Thanks so much, Judge.
Thank you. Enjoy the rest of your seminar and go to Mayfield and see the peacocks.
Yes, ma'am. It's a nature preserve too. It looks fun.
Oh yeah, it is. And do you know at that place, that's the first time I saw a peacock that was completely white.
Oh wow, I've never seen an entirely white peacock.
Yeah, entirely white, but they still had the plumage.
Now I need to go.
All right, have a good one. Enjoy your seminar.
Thank you, Judge. Good to see you.
Perhaps he tangled with that peacock and he's just not talking about it. Something happened to that man. Something fierce. I hope he heals up well, though. Judge Stevens, let's go back there.
But he did tell me he needed these only.
How do you pronounce your last name?
Soraya.
Soraya? Sarah?
Yes, sir.
All right. Jovan, Sarah, are you charged here in 25 CR 1196 with evading arrest or detention with a motor vehicle?
Yes, sir.
If convicted, it's a third-degree felony, which carries with it no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. Do you understand?
Yes,
Serious.
sir.
All right. And Mr. West is your attorney. Have you had a chance to talk to him yet? No? Does that no? You have to speak out so she
No,
knows.
sir.
Okay, yeah. You need to. You need to be in contact with him as soon as possible. Because again, you're looking at up to 10 years in prison. That's serious. Yeah. I'm going to reset this for 2 weeks. God bless you.
God bless you.
And did you ever did you know Mr. West was going to be your attorney?
No, sir.
Okay. Okay. He's one of the public defenders. So please note on these two that they are waiting to hear from him. He needs to contact them. And I'm giving him 2 weeks. Okay. Thank you. Get a resetting for that later, sir. Thank you.
Time return the highlighted X.
Dale Damond Langston.
Oh, Judge, that's the
I need some.
defendant that is in TDC.
Is he? Well,
He is.
This guy's moving around. Nope, he's leaving.
Yeah. Yes, sir. I checked the TDC Ross number fine.
I'm sorry, sir. Did you have? We're good. You're just moving through? How's it going? Oh, okay. I mean, you're always in fine. You look like you're having a hike or a good time. He's gonna come back with a beer, watch. Jeremy Broussard. On Mr. Broussard, what are we gonna do, Mr. Banks?
So this is our first setting. I just spoke with the prosecutor and
How's that going?
it's going well.
Oh, that's good.
So I just received an offer and need to discuss it with the client and also the discovery that I got in yesterday. So I'll do that between now and the next setting and have something to
How much time do you?
30 days.
How about 4 weeks?
That's fine. Depends on if it's in February.
You give me 30 days and wisely you're putting that into a weekend. Good work. Good trip. But 4 weeks, good. All right, get a reset. Thank you. Yes, sir.
Thank you, Jimmy. I'll make them too.
Everything, Jansen, you need anything else? Everything?
No, thank you.
Okay.
Where are you gonna do it?
Cody Hatch. Cody Hatch.
Judge.
Mr. Crenshaw walked through and, we're gonna pass on that one since he did a walkthrough. Come on up.
Can we recall that in 5 minutes, Judge? So the prosecutor.
Yeah, you got it. Troy Steins. Oh, that's yours too.
Yes,
Was that another 5 minute?
please.
Okay. DeMarcus Jones. DeMarcus Jones. DeMarcus Jones is called in 25 CR 373. Is that you?
Yes, sir.
And Dustin Galmore is your turn?
Yes.
Have you talked to him today?
I haven't heard from him today either.
Sorry. Wait a little while. If he doesn't show up, I'll just have to reset it. And I don't want you to waste your time. So that's this. Stand by. Thank you.
Okie dokie. Let's go back to Judge Simpson. We'll spend a little time there.
Agreed to adjourn it until the 5th of November.
Defendant having waived formal reading. This is, my stickers are all out of order, folks. Defendant having waived formal reading. Asking that a not guilty plea be entered on Leonard. That not guilty plea. Pretrial in this matter will be adjourned to November 5th, 2025, 9 a.m. The bond in this case, bond will be set at a $5,000 personal recognizance bond. Order standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or illegal drugs. I will also indicate at this time he's not to enter any Sam's Club in the state of Michigan. All right. Thank you.
Thank you, Your Honor.
Court calls case People versus, is it Bella? That's a lot. Is it Liu?
Ash Feltus for the people.
Good morning, Your Honor. Alexander Homnowski with and on behalf of Vessel Leo. Your Honor, this is time and date set for arraignment pretrial. With regards to arraignment, we waive formal reading of the charges and stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Go ahead.
With regards to pretrial, we've come to an agreement. The agreement, the plea form has been submitted.
I haven't, and it indicates defendant would be pleading to, is he pleading guilty or no contest? Because I don't have the box checked.
And we're going to be
pleading guilty to the charge of retail fraud in the 3rd degree, the 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed. There is an agreement that the prosecutor will recommend HIDA. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Okay, have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
That's a lot for you.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the 3rd degree. That is a misdemeanor punishable by up to 93 days of jail. $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that, sir?
That's right.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you, and also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of February 24th, 2025, at the location of 3749 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, what'd you do at the Target that makes you think that you're guilty?
I took stuff that did not belong to me.
You went into the store, you took stuff and tried to walk out without paying for it?
Correct.
What kinds of things?
Miscellaneous dorm items.
Be more specific.
I guess there was bedding.
You're a student?
Correct.
And you were taking stuff for your dorm room?
Correct, Your Honor.
Store was open to the public at the time?
Sorry?
The store was open to the public at the time?
Correct, Your Honor.
You didn't have anybody's permission to take that property, did you?
Yes, Your Honor. No, Your Honor, sorry.
And let's make sure we have that.
Yeah.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
All right. And the property you took was property that was offered for sale by Target?
Yes, Your Honor.
Sir, I do have to advise you that if you commit misconduct as defined in the Michigan court rule between the time of my acceptance of your plea and the time of your sentencing, that you would not be entitled to the court would not be bound by any sentence recommendation, and the court would not be bound by any evaluation. You understand that?
Yes, Your Honor.
You understand also if that were committed that you would also not be entitled to withdraw your plea?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And has the court complied with the court rule?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2, retail fraud. Third, count 1 is dismissed. Pre-sentence investigation is ordered. Defendant is referred to probation. Pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. I said at 9 a.m. 9 a.m. or as your invite indicates. As the bond in this case, I'll set his bond at a $5,000 personal recognizance bond. Standard conditions, including no assaultive behavior. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes, Your Honor.
I'm also going to indicate at this time you're not to enter any Target store in the state of Michigan. You understand that?
Yes, Your Honor.
Your Honor.
Thank you. Court does call the case People versus Brandon Bovee.
Ashley Feltus for the people.
Your Honor, David Chan, on behalf of Brandon Bovee. Brandon, can you please state your name?
He did.
Way ahead of me.
Shan, you were hiding on that side. You know something? You're never on that. You're always over there somewhere.
I've been trying to go on the side of justice and light, Your Honor, so under
Wow.
this side is a
No, I'm not even going there. Go ahead. Did I said anything?
Tentatively, he is accepted into Lenawee County Treatment Court. He needs to get screened and assessed by their treatment team to make sure that he's qualified. I did actually talk to Judge Shadler yesterday, so it looks like it's going to be something that we can do, but he has to go through the process. And I understand the next date is the 5th of November, which is 3 weeks. I don't know whether that's enough time to get screened and assess. The treatment team meet, recommendation made, and acceptance happen.
What's my next date after that?
November 19th.
19th will be fine.
And there's something I need to talk to Mr. Shand about as well, Your Honor, so thank you for the 19th.
All right. November 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls the case People versus Salvatore Lorenzo.
Feltus for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Sal Lorenzo. Bless you.
Bless you. Your name, sir?
Salvatore Lorenzo.
Thank you.
Your Honor, we do have a plea resolution to put on the record today. Hopefully the plea form is in front of Your Honor.
It is. What's he pleading? Is this guilty?
Guilty, Your Honor.
All right. I have here that the defendant will be pleading guilty to count 2, attempted resisting and obstructing a police officer. That's a 1-year offense. Also count 3, operating while visibly impaired, the 93-day offense. Upon a successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Your Honor.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Salvatore Lorenzo.
All right. Sir, it is this court's understanding that you are going to be pleading to 2 misdemeanor charges. The first being the stated count 2 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Also, that you'll be pleading guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, up to a $300 fine. Up to a $300 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, Your Honor.
And understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You understand that you're waiving the rights on that form as well as particularly the rights contained under paragraph 5 of your trial rights?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
And because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
On the date of December 31st, 2024, at the location of Packard near Oakdale Drive, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
I had several drinks. It was 8 months ago. I had too much to operate a vehicle.
All right. Were you stopped by the police?
Yes, Your Honor.
Why'd they stop you?
I had a flat tire. I was driving on a flat tire.
You're not disputing the right of the police to stop you in this instance, are you?
No, Your Honor.
Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital?
Yes, Your Honor.
Was there a blood draw?
Yes, Your Honor.
Were the results of that blood draw 0.168?
Yes, Your Honor.
Do you have any reason to dispute those test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
When you came into contact with the police, what happened with your interaction with the police?
It was a poor interaction. I deeply regret it. I wish I would just have complied.
Okay, so what'd you do?
I was brought to the vehicle and I didn't put my leg inside the vehicle to be taken to the jail.
So they were asking you to get into the vehicle. They were arresting you.
Correct. Yeah. And I didn't.
And you just didn't put your legs in and tried to basically not get in the vehicle when you were ordered to get into the vehicle?
Yes, Your Honor.
Sir, if I accept your plea, you do understand that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, misconduct is defined under the Michigan court rules, that you would not be entitled to withdraw your plea, and any sentence evaluation the court would no longer be bound by. You understand that?
Yes, Your Honor.
Counsel, have there been any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
I do believe the court has complied with the court rule, but I would note for the record, that was not the only way in which the defendant resisted police officers that night. There was significantly more.
Significantly more? Like what?
Refusing to get out of the car, refusing all commands, refusing to get on a stretcher, refusing to put his body inside of the vehicle, refusing to let the vehicle doors be closed once he was put inside the police vehicle. I just think the court deserves the more accurate picture of what happened.
Is that correct, sir?
Yes, Your Honor.
Okay, I'm going to just advise you one thing. Thank you, Ms. Feltes, that when you go talk to probation and when you're dealing with this court, you might as well be straightforward and truthful, because if you're not, and I'm sure your counsel will advise you, bad things tend to happen. Are we understood?
Yes, Your Honor.
He wrote a very nice apology letter to the officers, Your Honor. He does feel quite bad about it.
Oh, I understand that. I'm sure he does. Usually when people get called to the table on something, they feel bad about it. I'm just saying he needs to be truthful and forthright with the court. Otherwise, that will be his second mistake.
Understood, Your Honor. Thank you.
Court.
And I apologize, I interrupted the ask if we were compliant, but I did thought the court needed to know.
All right.
Oh, yes, Your Honor.
All right.
Yeah, compliant.
Court will accept the defendant's plea. 2 counts, 2 and 3. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and victims impact panel. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond will continue. Do I have probation intake? All right. Sir, hold on the line. We're going to put you in with probation intake so we can start the process, okay?
Yes, Your Honor.
Thank you.
All right, let's switch it up. Let's go down to Louisiana, see what's going on there.
I'll be serving as the chairman today. My colleagues on today's panel are joining us by Zoom, Ms. Jerry Ledoux and Mr. Dan Ara. Headquarters staff, please introduce yourself for the record.
Jasmine Thompson. David Cavalier.
Okay. All right. And then Mr. Nicholas West.
Yes, ma'am.
Will you please give your name and DOC number for the record, please?
Nicholas Omar West, 73-1429.
Okay, and our remote location is Rapids Parish Detention Center. Is there any staff in the room that we need you to introduce yourself?
Yes, ma'am. Sergeant Stoneman.
Okay, thank you very much, Sergeant. Okay, do you have a questionnaire in front of you that you answered the questions and signed?
I couldn't find that to print out for him, ma'am, but he did have one, but we just don't have it with us.
Okay, well, they're gonna be able to put it on the screen and you can identify it and say, so that's you, sir? You signed it?
Yes, ma'am.
All right, that's wonderful. All right, so according to the questionnaire and the answers you gave, you're not eligible for appointed counsel. Did you retain counsel for today's hearing?
No, I did, but I didn't put it on the paper.
Okay, but he's not there or she's not there, right?
No, ma'am.
Okay. All right, and you want to proceed?
Yes, ma'am.
Okay, thank you. All right, the lead person that's been assigned your case is Mr. Danny Barra. He's going to review your violations and you can answer guilty, not guilty, with or without a statement. But first, we're going to hear from You have a supporter today. Don't have anybody here in opposition, but a supporter is Miss Middleton. She's your child's mother. Ms. Middleton, would you like to say what you need to? We can't hear you.
Can you hear me?
Yes.
Okay, yes, ma'am. I just wanted to put on the record that I feel like, over time people grow. And although we're young and we do have our differences and everything, it doesn't change the fact that Nick is a great dad and he's an active parent as well and a great supporter when it comes to our kids. And I know like the situation at hand involved both of us, but over time, like we had to learn not everything that we do and say not only impacts our kids, but it impacts us as well. And I have 2 babies out here, young babies at that. And every day I'm getting questions like, where's their dad at and who take them away, stuff like that. It's always going to be a time where you want the best for your kids and you feel like you're doing what's best for them, but I can't do it by myself. And I feel like every kid deserves to have both of their parents if that's possible. I wouldn't want him to be revoked. I would think that him being released would actually be better for not only myself, but our kids as well.
Okay. All right. Well, thank you very much for giving us your statement. We appreciate it. All right. Because there's no more supporters or anyone in opposition, Mr. Barra, who has the lead in your case, is going to read your violations and then take your answer of guilty, not guilty, with or without a statement. Mr. Barra.
All right. It's alleged that you have violated the conditions of your parole by not reporting to your parole officer or any agent since October 25th of 24. How do you plead to that violation?
Guilty. Guilty.
Guilty. All right. It's also alleged that you did not live at the residence on file as evident by the agent speaking with the resident and of the listed address at 3616 Vermont Street, Alexandria, and being informed that you did not live there. There's also evidence by speaking to Joisha Milton and her confirming that you have moved to several different addresses since being released and on parole and having never been notified to the parole office. How do you plead to that one about not giving the right address or staying at the same address that you gave them?
Guilty.
Okay. Number 4 says that you did not refrain from criminal activity as evidenced by your arrest on 4/2/25 for aggravated assault by the Pineville Police Department. The original charge was amended to criminal mischief, and you pled guilty to that charge and was sentenced to 60 days in Pineville. How do you plead to that?
Not guilty.
Guilty. Okay. We're gonna have to talk about that one. Number 9, that you agreed to visits at your residence. You have not agreed to visit at your residence because you have not reported any of your residences to the parole office. How do you plead to that?
Plead guilty.
All right. And number 10, that you have never made a payment and you're $252 behind on your supervision fees. How do you plead to that?
I plead guilty.
Okay. So looking at these violations listed out by the parole officer, you pled guilty to all of them except number 4, which is the one involving the criminal behavior. Go ahead. You want to talk to us and give us a statement about number 4?
Yes, sir. Well, on that day of April the 2nd, me and my children and the mother of my kids was at Builder Lake fishing. And we had moved to a resident that wasn't fit. And the agreement was with me and the landlord that he was going to reimburse our money. So when we saw him, we asked, could we have our money back? And he agreed, yes. But in reality, he really didn't mean to give us our money back. Instead, he just made a false report, and that caused me to be away from my children. I know it kind of sounds crazy, but That's really the truth. I really genuinely didn't do nothing. I didn't put my hands on nobody. I didn't get physical with nobody. I had my kids out there, and I had the mother of my kids out there, and we just were fishing, just having family time.
But you pled guilty in court.
Yeah, I pled guilty because him and his friend came in there, and I look at it like this. I already have a jacket, and I already been in jail. So instead, I just felt like by me taking a misdemeanor, I ain't honestly think it was gonna violate me. I just was trying to honestly get back out there to my kids. I have a sister that's sick. I have a child that's sick. And then I'm still working. I work at Crown. They deal with hospital linen, deal with gowns, baby clothes, bath towels. It wasn't much. I had just started working, so I wasn't able to pay my fees, but I can get my fees paid. I'm not no bad person.
Yeah, but we're not so much worried about the fees. We're more worried about the absconding and the conviction for that charge that you're saying you just pled guilty to get it over with, I guess is what you're kind of saying.
I'm not saying that I pled.
You're saying you're not guilty, but you just pled guilty?
I'm saying I'm not guilty, but I pled guilty. It's 2 against 1. I mean, it's me that's already in orange, and it's the mother of my kids. I feel like I didn't have no win, to be honest. That's how I genuinely feel. I didn't get physical with nobody. I didn't put my hands on nobody. I did not have no weapons. I didn't touch nobody.
What about the statements that I see in the police report about a switchblade and a jacket pocket and all that? What about that?
I
You
don't
got anything
own
to say about that?
Yes, I do, sir.
That's what?
I don't own no switchblade. I never had no switchblade. And that's the truth. That's the truth. When I was being detained, when I was being arrested, they didn't get no switchblade out of me. I didn't have no switchblade. Honestly, we was just out there just fishing, just having family time. That's the truth for answer.
Mm-hmm.
I'm not no bad.
Okay, I don't have any more questions. Does anybody else have some questions?
Ms. Ledoux?
Ask, yes. Mr. West, is this your first time on supervision?
No, ma'am, this is my second time.
What happened with the first time? How did it end?
It ended with me and the mother of my kids, the situation that she was speaking on. That's what I was on supervision for the first time. And
wait, you're a first class offender, correct?
yes, ma'am.
So you've been on probation before?
Oh, ma'am, I've been on parole this whole time.
Okay, so in 24, you paroled out on this obstruction of justice charge, and so you're currently being supervised on that, and you absconded for that, correct?
I've been on parole since well, my original sentence was 2018 of the obstructions of justice. Yes, ma'am.
Okay. So what I'm getting at is, did you know the rules? Did you know how important it was to report? I mean, why did you not report? Because that's what I'm most concerned about. We can't supervise someone we don't know where they are, okay?
And I take full accountability for that, and I really do. And I'm not gonna sit there and make no excuses for myself. When I got released October 2024, and I reported October 25, I had went up there and they asked me, did I need a job? And I said, yes, ma'am, I do need a job. But my parole officer went in that day. So they referred me to these classes. They're dealing with probation and parole. Even though I was wrong for not reporting, I still was going to all my classes. And it was mandatory for me to go to my classes, because if I didn't go to my classes, I was going to be incarcerated. So I completed my classes. I just ain't have time to get my certificate because I had ended up in jail.
Okay. So you weren't reporting, but you were going to classes.
Yes, ma'am. All my name is on paperwork.
And what were those classes that you were mandated to take?
It was dealing with trying to find a job and thinking for a change and
Is that at the Day Reporting Center?
yes, ma'am.
Okay. All right. That's great. Okay. I read the police report. I'm not as concerned about that. It seemed like it was handled, you know, and it's over, but I was wondering about why you weren't reporting. Okay, thank you.
Okay, I don't have any questions. So it sounds like it would be for your final statement, sir, but do you have anything else you want to add before we vote?
I just want to say, I hope I do get another chance to go back out there to society so I can start back working. I could go back to my job. I just want to be out there for my kids because kids don't ask to be here. And I'm not perfect. I'm not perfect at all. I made some mistakes down the road. And I just want to say that I apologize to the board for my actions. And they're growing up fast. You can't get time back. You can't get time back. I have a sister that's sick. She in and out the hospital. I have a child. He was born with a prune belly condition. He'll never develop muscle, so he gets sick easily. I just want to be there for my kids. I promise, if you do reinstate my parole, I'll report every chance, every second.
Is the panel ready to vote, Mr. Barra?
Yes.
Okay.
All right. Well, looking at this case, you don't give me much of a choice. You didn't report to the parole office and you got convicted of a new crime. So based on the fact that you got convicted of a new crime and absconded supervision from the parole officer, I have no choice but to recommend revocation of parole.
Okay, so that's rule 3 and 9, Mr. Barra?
Guilty on all of the violation.
Okay. Okay, Ms.
Including the number 4, because he actually pled guilty to the reduced charge.
Did, yes.
Mr. West, today my vote would be in lieu of revocation to send you to a transitional work program. And so you would be in the custody of DOC for the period prescribed for a transitional work program. And after that, we have a 0 tolerance for reporting.
So the rest of them, this is for in lieu of all of them, transitional work program. Okay, well, my vote is I agree with Mr. Barra because I did read the email and she said that the incidents that happened never should have, but I'm certain it won't happen again. And that there'd be better communication and better examples for our baby. He and I both understand the choices we make do not only affect us, but our kids as well. So she's saying there that what this was about did actually happen. So I'm finding you guilty of violation of rule number 2, 3, 4, 9, and 10. So today, sir, you have been revoked and the time is 9:16.
I still have a question. Before this end, I still have a question. Okay, that's your final revoke for that. And in 24, I just served 17 months for this. So I'm really still kind of confused.
Okay, we're signing off because we don't figure out time. So you can ask somebody where you're at to speak to someone about that, okay? Signing off at, Rapids.
Denied. So my biggest issue with that whole thing was when the one lady said what a great father he is. No.
Well, I guess that said
Somebody else had something to say about it. No, not a great father at all. But, you know, keep believing that, I suppose. Let's go back to Judge Stevens.
Here on evading arrest. We'll wait a little while. If he didn't show up, I'm gonna have to reset it. Yes, sir. Okay, sorry to waste your time.
Okay, really. Okay, we have a seat for Coach Hoffman in here, okay?
Sorry, I've got these other 6 pages and I'll get right to you. I'll get these up, when I get these other 6 pages done, I'll get right to you.
I'll just sit over here and drink.
Wait, where'd you get that copy?
It'll be rough.
Hey, didn't we raise the price on that copy, didn't we? For Corey?
Yes, specifically.
Is it Cody Hatch? You want to go? Okay, come on up. Cody, here's Corey. Corey, here's Cody. How's that going on the city council thing?
So it's a true taste.
Let me tell you,
Test
you're on
of
YouTube,
patience.
you know.
What's that?
YouTube. Did you change makeup?
I did. I'm going with
a little
dark,
darker fall.
How's it here? Is it all the shirt?
Finally. Okay, what are we going to do here on, and Mr. Hatch, 23 CR 1093, you're charged, as you know, with this operating a motor vehicle in a public place while intoxicated. And because you have these 2 other DWIs, every time it's a DWI, it's a felony. So you got to be careful. And this is a 3rd-degree felony, so you were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed in accordance with this case. So navigate through it. He's your guide through this minefield, and but it's fixable. What are you doing right now to immediately to make sure that you don't get in trouble again? Yeah, I guess you have an interlock device.
I was had it for all 2.5 years. I never blew positive.
Good Lord. It is. This was indicted 2 years ago.
Yes, sure.
What the heck?
The previous prosecutor on the case, we were working towards a misdemeanor. Now that we have a new assigned prosecutor, she's indicating that there's no chance of that. So we'll just try it.
Okay. All right. Then, yeah, this is stale. We got to work this thing out expediently, and that's way too long. Let me look at this one. But y'all didn't have a deal on the other previous? You didn't have a deal?
There was
the notes.
There's not anything in the file about reducing this to a misdemeanor, Your Honor.
Okay.
There's an offer on the felony, but
He wasn't operating as our defense, and so our experience injuries really don't like cases where people
Did they do a blood test or something on it?
yes, they did.
No, I never get those until the trial. What is it? What was
I believe
it?
it
It's
was
for
a
my
227.
curiosity.
227.
Oh,
BAC isn't the issue, Judge. As you can read in the PC.
well, yeah.
Lack
It says
of facts of driving. So,
okay. So he's asleep in a vehicle that's running, and nobody else is there, and the police. So it was just place to sleep or something.
it was a safe area. And case law is very clear. Engine running,
It's not.
Lucky you didn't get carbon monoxide poisoned. Well, that could have been dangerous. All right, let's set up a trial. Let's go. We can do that.
Great.
Troy.
Here you go.
Troy Stein.
Oh, here's.
Yes.
I need to do the
Troy.
That's also a new prosecutor, Judge. I'm gonna get.
I'm a prosecutor, but.
New prosecutor in the case.
He'd have been the last one.
Stipulate that.
He'd have been the last.
Very old prosecutor.
I'd have called that.
But new to this case, and I'm gonna get him some information, and if we could come
You
back.
didn't have information before.
Another announcement. Well, we've had a positive movement, so.
Hey, let me ask you,
Sure.
Corey J.H., you have two middle initials? I didn't know that.
I'll try to let you know.
I'll be doing it.
Yes. It's hell of a monogrammer. Yeah, they don't.
Wait a second. What'd you say?
Couple extra dollars.
Yeah, that's gonna cost you.
Well, no, they usually only will do 3 initials, so it has to be a special request. Just, it's a lot of paperwork.
Yeah, after this, he'll probably have 5 initials.
Yeah.
What are you gonna do today?
If we could just come back on another announcement, I think we'll get this one resolved.
Is 4 weeks good, you think?
Sure.
And
Reference
that was an old one too.
Christmas weekend.
Man, I don't know what you have filibustered long enough on all of these. This one's 2 years old too. Mr. Steins needs to move on with his life one way or the other, huh?
Well, we're certainly prepared. It's just a matter of which charge.
Good luck on this.
Seeing just right now.
All right. Get a resetting 4 weeks. Hopefully there'll be an end to this soon.
Yes, sir. Understood.
Highlighted next point.
Yes, ma'am.
Thank you, Judge.
Is that
Good
it?
to see you.
Oh, cool.
For Mr. Crenshaw.
There you go, man.
Yesenia
Thank you.
Alvarez. Yesenia Alvarez. Getting nothing done today. Just spinning our wheels today. Getting nothing done.
No.
Mine. You're not gonna like my response.
25 CR 348. Yesenia Alvarez. That's you? Says Langston Adams. Was Langston Adams representing you for a while?
No.
No?
Pointed out at the jail, Judge.
Yes, I believe
Sometimes
that's
that
what
happens
happened.
when they're in there.
Because that's what's showing on the
Wherever they
jacket.
pointed at me.
Okay, you're charged with state jail felony, operating a motor vehicle with a child under 15 years of age, which carries with it up to 2 years in the state jail. You got it? You have to speak out. Yeah, you understand? Okay. It's the least serious type of felony, but nonetheless, who wants a crime, right? So work it responsibly with him. What are we gonna do today?
Judge, if we could get 30 days, so I can work through this with the prosecutor.
4 weeks good?
4 weeks.
Okay, get a resend. Thank you. Francisco Torres. Francisco Torres. 23 CR 5 3.
Sign on the highlighted next one, then.
Judge,
This
Mr. Boyd and I had been.
DWI.
Yes, sir.
Okay, and it's a 3rd-degree felony. You're looking at no less than 2, no more than 10 years confined in prison, up to $10,000 fine if convicted. So it's serious. You want to deal with it responsibly. What do you want? Judge, well, these are 2 years old now.
We've got shuffled around to some prosecutors. So, but I think Mr. Boyd and I were close to working out a deal on this. I haven't seen him yet this morning, but it was in the back. It wasn't. Maybe
is Dan here?
He was earlier. He's getting getting ready for some hearings this afternoon.
We don't have an reach to get that.
It's 2.5 years.
I know.
Well, can you get an agreement in 5 or 10 minutes? I mean, it's a DWI. These are never mysterious. There he is. You know Ryan Gertz?
Yes, sir.
Attorney.
I texted you this morning about this.
Okay. You want to go out and get a beer first?
Yeah.
Come back and see what happens? Okay. He's 2 years old, DWI, and on Francisco Torres. I think you inherited it.
Yes, sir.
And I think Ryan doesn't want to wait forever either. So can y'all work on this one?
Yes, sir.
While everybody's here? Okay, good. Let me know.
Give us a few minutes.
Yeah. All right. Tommy Perkins, Nolan.
All right, let's switch it up a little bit. We'll go to Reno, Nevada, Judge O'Neill.
Ms. Bruce, your case number is 25 CR 14183. I'm opening up your file now. All right, and Ms. Bruce, it looks like on September the 22nd, 2025, you were charged with trespassing and possession of drug paraphernalia. You were given citations for those two offenses in order to come to court on September the 24th, 2025. Did you appear for court on September the 24th?
I did not, Your Honor.
All right, so are you admitting that you failed to appear? I'm sorry, I didn't hear you.
Yes.
Thank you. And do you understand that failing to appear is contempt of court, for which I could sentence you to up to 25 days in jail and fine you up to $500?
It's fine, I understand.
All right. And have you served in the United States military, Miss Bruce?
No.
All right, I'll accept your admission to the failure to appear as freely, voluntarily, and knowingly entered. Is there a negotiation to be tendered to Miss Bruce based upon the charges?
Yes, Your Honor. If she is willing to plead to the trespass, the city would move to dismiss the paraphernalia.
All right, Miss Bruce, do you want to take advantage of the city attorney's offer here this morning?
Yes.
All right, and what is your plea to the charge of trespass?
Guilty.
You understand by entering a plea of guilty or no contest, you're giving up your right to have a trial on the trespass?
Yes.
Did you have any question about your constitutional rights?
No.
All right, we've already established that you're not a veteran, so I will accept your plea of guilty to the trespass. I will dismiss the paraphernalia charge pursuant to those negotiations. City's recommendation is to sentence.
Your Honor, Ms. Bruce is a person who has a history of nuisance offenses with our court dating back to 2022, accounts 7 trespasses. She's escalated to a simple battery. She's clearly struggling with a substance abuse issue. So this would be a case that I would ask for a referral to community court, but that's no longer an option. So it's tough, but I think the best approach here with this history, Ms. Bruce clearly needs help, but I don't know if she has the tools to be able to go out there and secure that help on her own. So a couple different recommendations here. If she's able to go out there and get help, I would ask that she go to, I don't know if Puff House would be appropriate or any of our other treatment providers in town and try to get some substance abuse help there. If that's not an option, I'm going to ask for a suspended sentence with a no contact order with this particular apartment complex, which is the Latitude Apartments. She was found urinating in the common stairs in that building with a no contact order, obey all laws, and no drugs and alcohol. And of course, we know that if she doesn't get help, it's going to be a revolving door where we're going to continue to see her coming into the jail. So I'm going to ask for 45 days suspended. Thank you, Your Honor.
Thank you, Ms. Boydes-Tanner. Mr. McGinnis, on behalf of your client, what would you like to add, sir?
Thank you. This failure to appear was for a community court case. I know that she has been active at some point in time with community court. Again, it's unfortunate they're no longer in existence. She has 3 days credit time served. She informs me that upon release from custody that she's going to go down to the R place. She's going to start working with a case manager, and hopefully they'll be able to direct her to the resources that she needs I don't think a 45-day suspended sentence is appropriate for somebody who's mentally ill and homeless. I think there's other avenues to approach that, perhaps maybe a 15-day suspended sentence, but she's been in custody for 3 days.
All right, and Miss Bruce, I'd like to hear from you. You understand that you've been trespassed from that apartment complex, and if you go back there for any reason, that they'll arrest you and take you back to jail. Do you understand that?
Yes, and I haven't been back there since.
Okay, what would you like to tell me about your plans to stay out of jail in the future?
I'm gonna move to a different state.
What state are you going to move to?
California, back to where I was originally from.
All right, and where is that?
Palm Springs with my Uncle Jade.
Okay. All right, well, here's what I'm going to do. I concur with Mr. McGinnis's argument that people who have some mental health issues shouldn't be just warehoused. I'm going to sentence you to 15 days in the Washoe County Jail. I'm going to suspend that sentence for a period of a year on the following conditions: that you obey all laws, you stay away from the Latitude Apartments, you have no alcohol or drugs without a valid prescription, including marijuana, and that you seek help when you're released. If you want to go to our place or something along those lines, I want to see you participate in some kind of mental health program so you stay out of custody. Do you understand?
Currently, I have my clothes and I have a bed there. So yeah, I have a bed.
Good. All right, you should be released today with those conditions.
Yeah.
Sergeant, what's the sentence on the contempt charge?
Time served.
Thank you.
Thank you for reminding me. Hannah Paris? Miss Paris? Good morning, Miss Paris.
Innocent, yeah, innocent. Sorry, innocent. Innocent.
Hold on, Hannah. Hold on.
All right, just a minute. I have to pull up your matter. Just give me a second. My computer's a little slow this morning. It must not like the rain. All right, Miss Paris, your case number is 25 CR 15080-02. And you were charged on October the 10th, 2025 with 3 crimes. They are resisting a public officer, trespassing, and petty larceny. Did you understand those charges? You have to answer out loud.
Yes, I understand. Yes, I understand.
All right, and Ms. Aboitis Tanner, is there an offer to be tendered here?
Your Honor, Mr. McGinnis may have more information on this than I do. I've handled a couple of Ms. Paris's cases within the last year, and she's been found incompetent. I wonder if Mr. McGinnis has any insight on that.
Thank you. I will note for the record that her twin sister, Ashley, was found to be incompetent last week by me. So, and I believe that there was a birth issue relative to both of these young women that may have resulted in some of these findings. Mr. McGinnis?
It's my understanding there was a competency evaluation on Miss Hannah Paris, and it found her competent. I'm looking at my computer again, it throws up, but it's in on 10/11/2025, it's in Odyssey.
I see that. Thank you. So based upon that finding, Ms. Aboitis Tanner, is there an offer to be tendered to Ms. Paris?
Thank you, Your Honor. If she pleads to the petty larceny and the obstructing and resisting, the city would move to dismiss the trespass offense.
All right, Ms. Paris, do you want to accept that offer? Ms. Paris, the city attorney has offered to dismiss the charge of trespass if you enter a plea of guilty or no contest to resisting a public officer and petty larceny. Did you understand those charges?
Innocent.
All right, we'll go ahead and enter a plea of not guilty. We'll schedule the matter for trial.
Your Honor, she currently has another case that is set in Department 1 for November 12th at 8 a.m.
Good. Let's go ahead and consolidate the matters if no one has any objection. We'll set the trial in conjunction with the other matter. All right, the next matter is Maria Phillips.
Your Honor, did you want to set bail on that or?
Had bail been set? I see here that it has been previously set, Ms. Massey, at $1,500 bondable. That bail amount will remain in place unless either of the lawyers wish to be heard as to that issue.
No, Your Honor, thank you.
Submit it.
Thank you, Your Honor.
All right, we'll go on to Ms. Phillips. Good morning, Ms. Phillips. Your case number is 25 CR 15254. I'm opening up that matter now. And it looks like on October the 13th, 2025, you were charged with domestic battery first offense. Did you understand the charge? I'm sorry, your microphone is muted. Deputy, could you unmute the microphone so I can hear the plea? Thank you.
Yes, Your Honor.
And you understand the charge. What is your plea to the charge of domestic battery first offense?
Not guilty, Your Honor.
All right, the court will accept your not guilty plea. We'll schedule the matter for trial. Can you afford your own lawyer?
No, Your Honor.
I'll go ahead and appoint a legal defender to represent you, and I will order, Ms. Phillips, that you make contact with that lawyer in about a week to 10 days so the two of you can be prepared to proceed to trial. Do you understand? It's very important that you make contact with your lawyer prior to the trial date so they'll know your side of the story, what your possible defenses are. Do you understand?
Yes, Your Honor.
I may have a trial date with a legal defender for Ms. Phillips.
Yes, Judge, I have December 4th at 8 a.m. with Kathy Burning.
All right, Ms. Phillips, your trial date is December the 4th. The time is 8 a.m. and your lawyer will be Ms. Kathy Burning. She's one of our more seasoned legal defenders. You'll find that she's very easy to work with, but you must contact her so she knows how to reach you and to go over the facts and the circumstances of your case. Do you understand?
Yes, Your Honor.
All right, and let's see. I don't see that bail has been set in this matter. Does the city wish to be heard as to bail?
Thank you, Your Honor. On the MPRA, Ms. Phillips scores a 2. On the pretrial assessment report, we learned that she's employed full-time, self-employed as a lash artist. She reports that she's been in the Reno area for 8 years. She's 32, current residence for 1 year. And she reported that she has no alternate residence if released from custody. As far as what's included in the probable cause statement, we learned that she was intoxicated when this alleged offense occurred, that she allegedly pushed the victim, her significant other, grabbed her arm and bit her on the cheek. With regards to her criminal history, she's been in the system once before, and that was in June of this year for carrying a concealed weapon without a permit. I am going to ask for the lower than the standard 3,000, Your Honor, because of the MPRA score of 2, but because of the violence, which includes a bite to the face and the weapons charge, I am going to ask that you impose bail in the amount of $2,000, that you make that bondable, that you order her to abide by no contact order with the alleged victim, subject herself to enhanced supervision, and if she has any weapons, that she get rid of them pre-trial. Thank you.
Are you seeking a no contact order, counsel?
Yes, Your Honor.
May I have the person's name?
Absolutely. One moment, please. Danielle Rogers.
Thank you, Mr. McGinnis. Your response, sir?
Thank you, Your Honor. I'm without her criminal history. I have a question for the city attorney. I know that you indicated that she was charged with carrying a concealed weapon. Was that charge dismissed?
I don't have a disposition noted, Mr. McGinnis.
It's my understanding that charge was dismissed, Your Honor. I don't think that should even be considered because it was not a conviction. My client's 32 years old. She has stability in this community the last 8 years. She owns her own business. She is a lash artist. She has been doing that for the past 4 years. She doesn't have a history of failures to appear. In fact, she has no failures to appear. I don't think the city's met its burden or any Valdez Jimenez for a monetary bill. I think that the least restrictive means to supervise her, and that means that you can do an enhanced supervision with alcohol testing. Again, 32 years old, limited criminal history. It sounds like she has an arrest for a concealed weapon that was probably dismissed according to my client. She suffers from borderline personality and anxiety. She's not receiving her medications at the jail. She does have a doctor when she's released. She can take those medications. She does have an alternate place to live other than with the named victim. Again, her NPRA score is a 2. Would ask that you consider an OR release with enhanced supervision.
Thank you. So Ms. Phillips, I've heard mixed messages relative to whether or not you have an alternate place to live.
Yes.
If you're released from jail, do you have a place other than with the victim to go?
Yes, I do. I have.
And who is that person, or where is that?
My friend Andy can take me. She's here right now. Close to my son.
All right, based upon what I've heard here today, I'm going to go ahead and release you on your own recognizance, which means I'm trusting you to make all of your court appearances and to follow my instructions. If you do not, you will come back to jail and wait in jail until your trial date. Do you understand?
Yes, I understand.
All right, so the conditions for your release will be that you obey all laws. You have no alcohol or drugs without a valid prescription, including marijuana, that I'm going to place you on enhanced supervision with testing. You'll have no contact at all. And you understand what no contact means?
Yes, Your Honor.
And that is with Danielle Rogers. So if you have any social media texts, driving by her home, by her work, any attempt to contact her through a third party, you'll go back to jail and you'll sit in jail until December the 4th, 2025 at 8 a.m. when your trial is set. Do you understand?
Am I able to get my stuff? Because
Yes.
I do lash
Yeah,
stuff.
so Mr. McGinnis can advise you, but you can call the non-emergency line of the Reno Police Department and request a police officer to stand by while you collect your personal belongings. Do you understand?
Yes.
All right, do you have any other questions?
No, Your Honor.
Are you released on your own recognizance? I will order that you, upon your release, you get over to the Reno Municipal Court and set yourself up for supervision. Do you understand?
Yes, Your Honor.
If you don't do that, I'll have you back in jail tomorrow.
Okay.
All right, that'll be my order. Kirk Halderman.
Yep. Good morning.
Good morning, Mr. Halderman. Would you please tell me how you spell your last name?
Helderman.
D-E-R, Halderman. Thank you. It's misspelled in both my notes and in the jails in Odyssey. So it's Helderman, correct? All right, sir. Your case number is 25 CR 15077. I'm opening up your file now. It looks like on October the 10th, 2025, Mr. Halderman, you were charged with trespassing. Did you understand the charge?
Yes.
And how do you wish to plead to that charge?
Guilty.
Sorry?
Guilty.
All right, sir, you understand by entering a plea of guilty, the court, you're giving up your right to have a trial in this matter?
Yeah.
Did you want, if you would answer yes, it's easier to be picked up on the microphone. Thank you. Did you understand your constitutional trial rights?
Yes.
Or do you have any question about your rights?
No.
You understand that trespassing is a misdemeanor offense for which you could be sentenced up to 6 months in jail and fined up to $1,000?
Yep.
All right. And have you served in the United States military, sir?
No.
The court will accept your plea of guilty as freely, voluntarily, and knowingly entered. Ms. Boydes Tanner, on behalf of the city.
Thank you. Thank you, Your Honor. It looks like this is a trespass at the Pepper Mill. We have not seen the defendant since 2021. He's been in custody for 4 days. So at this point, I'm not going to object to time, sir.
Thank you. Want to add anything, Mr. McGinnis?
Submit, Your Honor.
All right, thank you. Mr. Halderman, would you like to say anything, sir?
No.
All right, so I'm going to advise you that you have been trespassed from the Peppermill. They have a legal right to keep you away from their casinos, and I say that plural, which means also the Western Village out in Sparks, for a period of up to 3 years. So please, I'm going to order that you stay away from the Peppermill so you don't end up back in jail. Do you understand?
Yep.
You're sentenced to time served.
Thank you.
You're welcome. Kayla Thiel. Good morning, Ms. Thiel. Am I pronouncing your last name correctly?
It's close enough. It's Thiele.
Thiele, thank you.
Yeah.
Your case number is 25 CR 15213. I'll open up that matter in my computer now. And it looks like on October the 13th, 2025, you had 2 alcohol-related charges. The first is minor in possession of alcohol and minor consuming or purchasing an alcoholic beverage in public. Did you understand those charges?
I understand.
All right, and is the city prepared to tender an offer here?
Yes, Your Honor. If Miss Tile is willing to plead to the minor purchase, consume alcoholic beverage and public offense, the city would move to dismiss the MIP.
All right, and Ms. Thiele, do you want to accept that offer? She's going to offer to let you plead to one and dismiss the other.
Does that mean I would be released?
No, I don't bargain with people about their release. We're talking about your entry of plea here today.
No contest.
To what?
Both of them.
Okay, I'm only going to take a plea to one of them. The city attorney's offered to dismiss the other. So as to the minor purchasing or consuming an alcoholic beverage in public, is your plea no contest?
Yes.
And do you understand by entering a plea of no contest, the court will find you guilty of that charge?
Yes.
Did you understand your constitutional trial rights?
Yes.
Do you have any question about your rights?
No.
All right, and have you served in the United States military?
No.
The court will accept your plea as freely, voluntarily, and knowingly entered. I will dismiss the minor in possession of alcohol charge pursuant to your entry of plea. Typically, the law provides some relief for these people who are young people who are charged with these alcohol-related charges, including actually no jail time. So she must have been grossly intoxicated when the officers found her, or she would not be in jail. I'm inclined to follow the law and allow her to have this charge expunged from her record upon completion of community service and the victim impact panel. Does anyone have any objection?
Your Honor, may I be heard?
Absolutely.
Of course, I'm aware of what the law is. My concern here is that this case is more aggravated than our traditional MIP. The reason for that is because I'll start with what happened. She stole a bottle of rum from a business. The business didn't want to press charges. That's why she's not here on a petty larceny. But she drank 1/3 of the stolen bottle within a short period of time. Her PBT was at a 0.189. She indicated to law enforcement that she stole the bottle so that she could be arrested. It indicates to me, Your Honor, that she's struggling. It's more than just a substance abuse issue. And then I see her in that garb. I have some concerns with her just being released. I don't have an issue with the expungement, but I think we should try to get her some help. I would ask for a substance abuse evaluation, see if we can schedule one quickly. I fear for her safety if we were just to release her from jail today without any services in place. Thank you.
Thank you, Mr. Boydes-Tanner. Mr. McGinnis, you're
I
in.
think you're right. I think the law is pretty clear. They have the right to expunge this type of offense. I could tell you that my client, and it's warranted, what the city attorney saying it is concerning seeing her up in the turtle suit itself. She was struggling quite a bit that day. She wanted to be arrested because she didn't think there was any alternative to that day other than being arrested. She does have a therapist. She does do the DPT skills with her therapist, and she does have a stable place to live with her family out in the North Valleys, including her sisters, brothers, and mother and father. Upon release, she'll go back there and she'll continue with her therapy. I think she was just having a very difficult time that day. Stole some alcohol, drank, and ended up in custody. I don't know what the alternative would be under this situation. It sounds like maybe a status review to make certain that the victim impact panel is done, make sure that the community service is done, and make sure that she's following up with her therapist. Maybe that's the best approach.
Thank you, Mr. McGinnis. So, Ms. Thiele, I want to talk to you a little bit. This is very concerning because even the Nevada legislature, which is often not very insightful, but here they indeed were, they understand that there are a lot of young people who get to the ages of 18 to 21 and experiment with life's challenges, including alcohol and drugs. And they do not want you to have a criminal record because you were experimenting and maybe even learned a valuable lesson, which I'm hopeful that happened to you, and allow you to have this charge removed from your record upon completion of some obligations that I intend to enforce. Are you willing to participate in anything I direct so you can have this charge pulled from your record?
Yes, Your Honor, and I would like to add something, please.
Yes.
I can get it set up with my therapist to attend an actual DBT group for adults at Great Basin Behavioral Health.
Okay. You know, one of the conditions of your release, what I'm going to do is I'm going to set this out for 6 months. But in the meantime, I'm going to have you come back in 30 days and provide proof that you've done the things that I'm about to order. So they are as follows. First, that you continue with your therapy, and that should include some substance abuse counseling. And I want you to, when I see you next, and we're going to set a date about 30 days out, so you can bring proof, it would be by letter, that your therapist says that you're regularly attending and that part of your treatment includes substance abuse counseling. Do you understand?
I understand.
All right, the conditions of your release and this deferred sentencing will be as follows: that you obey all laws, you have no alcohol or drugs without a valid prescription, including marijuana, for the next 6 months, that you that you participate in your ongoing therapy session, and that you probably need to stay away from the place where you are accused of stealing the alcohol. What place would that be, Mr. Boydes-Tanner?
I stole it from Rayleigh's.
All right, so you're ordered to stay away from all Rayleigh's because they probably have a no trespass. A lot of these places, the businesses now have facial recognition. So if you pop in to grab some milk, they'll probably arrest you for trespassing. So I would suggest that you go to other stores other than Rayleigh's. Do you understand?
I can do that.
All right, so what I'm going to do now is I'm going to schedule a case status hearing for you. At that date, you're going to provide to me proof that you have, I forgot. I am required by the law, in order to dismiss this charge, ultimately, you have to do some kind of alcohol counseling. And my personal favorite is the Victim Impact Panel, which is a group setting once a month of family members and loved ones of people who have been killed or seriously injured by DUI drivers. So you get a chance to see that being grossly intoxicated, you were more than 3 times the legal limit when you were arrested and brought into jail. And I just want you to know that that's going to have serious consequences on your brain development. So you need to stay away from alcohol for the next several years, at least until you're 21. Do you understand?
I understand, and I can do that.
Very good. So what I'm going to do now is set a case status hearing for you to come back and see me with proof that you're continuing your therapy and that you have completed your Victim Impact Panel. Perhaps we should set it out 45 days, since the Victim Impact Panel is offered monthly.
Thank you.
45 days would be the first week in December. Do we have a date that first week in December, please?
Yes, Judge, I have December 3rd at 8:45.
All right, so Ms. Thiele, I will see you back in my court on December the 3rd at 8:45 with the proof that you have done the victim impact panel and you're continuing in your therapy. Do you understand?
I understand. Thank you so much.
You're welcome. And do we need to set a 6-month date for?
Okay, real quick in the chat, a 1 if you want to stay here, a 2 if you want to go to Louisiana. 1 for here, 2 for Louisiana. Go. Tell me what to do.
Your Honor, is she going to report upon release? I didn't hear that.
Thank you, Mr. McGinnis. That's an excellent suggestion. I want you to go to the Reno Municipal Court when you're released, Ms. Thiele, and they will give you the information relative to the victim impact panel and anything else that you need to accomplish my order, okay?
Thank you.
And that date 6 months out should be end of
Judge,
April.
I'm getting one from Alexa.
Okay, stand by, Ms. Thiele. That's a little bit out of our calendaring slots right now.
By a vote of 4-2, Louisiana.
Us by Zoom, Ms. Jerry Ledoux and Mr. Danny Barra. The panel today is at DOC headquarters in Baton Rouge. Today's remote location is Bossier Medium Correction. Staff, will you introduce yourself, please, for the record?
I'm sorry, can you hear us now? Okay.
You can introduce yourself for the record, please.
Yes, ma'am. My name is Jason Johnson. I'm one of the program managers at Steve Oil at Bossier. I'm Deputy Terrence Stanford, classification deputy here at Bossier Medium.
Okay, thank you. Okay, so I would like for, I hope I say it right, Mr. Grubleys to introduce himself with his DOC number, please.
He's just next door. He's on his way.
How do you pronounce his last name?
I believe that is correct.
Grubleys, okay.
Still, okay, all right, here we go, let's see. No. All right, there we go, thank you.
Mr. Grubleys, am I pronouncing your name correctly?
Yes, Modestus Grubleys.
Okay. Will you introduce yourself, your DOC number for the record, please?
774755.
And then say your name.
Modestus Grubleys.
Okay, thank you very much. I'm going to read out some information, and at the end, you're going to verify if I'm correct, okay? You ready? All right, so we're going to start with your name, Modestus Grubleys, DOC number 774755. You're a first-time felony offender. Your offense is money laundering, 2 counts. Theft over $500, 2 counts. Your sentencing date was 12/5/2022. You were sentenced to 15 years DOC. It was 4 times running concurrent. Parole date is 3/23/2026. Good time date is 9/28/2026. And your full-time date is 6/23/2037. Is that correct?
That's correct.
Okay. So I have here that the classes that you've taken, well, before we start, we don't have anybody in support of you today, but we have somebody in, her name is Lisa White. She is here in opposition. We will let her speak. Ms. White, you want to get up and speak? Morning.
I'm here on behalf of myself and Kevin Jordan for the fraudulent transaction for February 2022, about 28,000. We feel one of the things is we must use money again, but he says he's going to do restitution. I honestly don't believe that. I want to point out that this has become very emotional and stressful for all of us, not only for me, as I was the one that did the majority of the transaction for Mr. Jordan, who's my boss. But I was also in contact via chat, through this whole thing. The whole actions look pretty legit. So now, when we try to do any kind of transactions online, you kind of like have to do double work trying to make sure that everything that you're doing is correct. So it's real stressful. It causes more work for me and my employees to make sure that what they're doing anything online is legit. It's kind of like being violated at your home, especially for the amount of money. As far as restitution, I honestly don't think that will ever happen if he gets released. Especially the fact that he's, going, not coming back here. My understanding, I think he should serve his time. I think the time that the 15 years should be served, because that's just the way we feel. We feel that because we just don't think that we'll ever see our money again. We're a business, we don't take that lightly as far as losing that much money on something that we really thought was a legit purpose.
Yes, ma'am. Thank you for coming here today. Thank you very much. Okay, Mr. Grubblies, would you like to tell us in your words why you're incarcerated and why we should release you early?
Due to my language barrier, I wrote down some notes that would help me this day, and my family did wrote emails on Monday for supporting me. I want to ask you, did you receive them?
It was sent Monday?
Yes. My brother and my mother sent the emails to parole board at la.gov.
We'll review the packet. Just go ahead with your statement, please.
Oh, okay. Good morning, everybody. I took full responsibility for what I did, and now I understand that my actions was wrong. Communication skills kept me out of trouble, helped me express myself, and I stayed around positive people that want to help me and help themselves. I did a lot of group exercises in the dorm that really helped us feel better and healthier. My mom and my brother has been supporting me all the time while I was incarcerated, and they still supporting me, and they will support me mentally, emotionally, and financially. My general comments to you are that I feel that I should be paroled because I finished Steve Hall intensive substance abuse program. I finished anger management class. I finished domestic violence class. I finished parenting class, substance abuse class. I read a lot of self-help books. In rehabilitation, I learned that substances are bad and anger and domestic violence is horrible, and that you have to be positive towards family and others. I took this prison sentence the positive way, mentally, physically, and emotionally. I strengthened bond with my family and communication skills. I learned that my actions not only affected me, but my family, community, and friends and loved ones. I learned that I was wrong. I read a lot of books. I did a lot of studying towards better future. I feel clear as ever before. I can think clearly. I did partake Bible study and meditation and fitness. I stayed planning my roofing and landscaping future businesses. I'm planning to build a new house for me and my family. I have also developed problem-solving skills along with learning how to express myself. All these things help me learn about myself, how to keep myself on the right tracks as a person, and to take myself from ever being incarcerated again. At the time when I took wrong actions, I wasn't thinking about myself, but through incarceration, I have changed. My thinking and behavior have changed too. I follow the rules and help myself and others for the sake of good. Dear board members, at this time, I would to thank you for this opportunity today, for allowing me this time for ability to express not only all that I have learned and accomplished during my incarceration, but all the ability to show you as well for this hearing and express to you how I feel and what it means to me be better for myself, family, and friends, and the community. It is my most sincere prayer and hope that you would not only trust me, but also the things that I learned from my treatment and classes during my incarceration with Steve Hawley Intensive Substance Abuse Program, that you will allow me to put these tools I learned to work by allowing me the blessing of parole. Thank you for your time and consideration upon my release.
Thank you very much. Staff in the room, do you have anything that you would like to say to us, add?
This is Lieutenant Roberts. We have not had any behavioral issues from him at all. So there's no disciplinary or anything like that. And he was in the program, and Shyshaft could probably speak a little bit more on his behalf.
What he said is correct. He completed 9 months of Steve Boyle as well as domestic violence training. And I have no record of any treatment write-ups for him while he was here.
Has he completed the 100 hours of pre-release?
I do not believe so. Do you think you've done that somewhere else? Pre-release?
No.
Okay. I don't think he has.
How about GED?
GED, I tried, but they stopped doing this over here, right? Yes.
And it's starting back up.
Oh yeah. I tried, but they stopped it.
All right. And are y'all aware there's an ICE detainer?
Yes, sir. Yes.
Okay. Thank you.
Well, today, your case is assigned to me, and I've listened to all of your accomplishments, which are wonderful.
Thank you very much.
And all the plans that you have for your life and the people around you, people close to you. But you never did mention restitution. There's one fella, $55,000, and the lady that just now spoke, $28,000. And you're planning to build a new house. So where does your restitution fit into all of that?
I have a lot of experiences in landscaping and roofing businesses. So I will start work as soon as I get adapted to the community, and when I start feel better, and I will start working and pay restitution.
Ask you something, because you did mention the consequences for this behavior to your family.
Yes.
You talked a lot about that, which is very good, but I didn't hear you say what the probable consequences were to your victims that lost that amount of money.
I did wrote down, and I understand that I committed a crime and took full responsibility for it. I would like to apologize to my victims for what I've done. I'm sorry. Being incarcerated, I learned a lot about myself and others. I learned that to understand what's wrong and what is right in life. I learned that this is not the life I want to live. I want to live a good life. I learned that family and friends are very important to me and also to my victims. I would like to be with my family. And rehabilitation program helped me see that drugs and domestic violence is horrible. I learned to be patient and polite towards society and public. I'm ready to seek employment and work and have a fresh new start and pay my victims restitution. And to come back home to my loved ones. Thank you for helping me become a better person.
Thank you very much for reading that. I appreciate that. I don't have any more questions. I want to say that you have complete opposition from law enforcement and the AG. And then Mr. Robert mentioned the detainer. Does anyone else have any questions, Mr.?
I would like to know, how, when, and why did you come to the United States?
I came to the United States in 2021 and as a tourist, and what happened was that my bag got stolen with my property, and that's what led me to get in trouble.
Okay.
Mr.
I have a question. What were you taking the money for? What did you need that money for?
I really didn't mean to steal it, but I did, and I feel bad about it. And at the time, I wasn't really thinking about myself or the others, that I'm affecting them the wrong way. And I just learned that I won't do this again. And this is
my question is, what did you spend the money on? Why did you steal it? What did you spend it on?
I just on everything, on rent, on a lot of it got missing, and I couldn't hold on to them because my property got stolen.
Okay, thank you.
Is the panel ready to vote?
Yes.
Okay. All right. Well, I'm the lead, so I'm going to vote first today. And I'm going to vote to deny your parole based upon strong law enforcement opposition, victim opposition. You do have a detainer. So those are my reasonings. Ms. Ledoux?
My vote would be to grant to the ICE detainer and have him deported immediately.
Okay. Mr. Barra?
I'm going to concur with Ms. Ledoux. Grant to ICE detainer only for deportation and order he pay restitution to the victims in the case as ordered by the judge in the court.
Okay. Today you have your parole has been denied, and you heard the vote of Mr. Barra and Ms. Ledoux to grant you to go to ICE for deportation and to pay your restitution. And then I voted to not grant you parole either. So that concludes us at is that the last one at this location?
Okay, so I'm not going to play neither the denied nor the approved stinger because I approve of his denial. It kind of both fits. I very much like the fact that we're going to send him out of the country because let's get this straight. A few years ago, he arrives in the country and he's like, you know, it's beautiful here. Nice country, good people. I could really rip him off. Nope, 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 nope. Double nope, triple nope. Go away. Go away. Get out of our house. So I'm very, very happy with that decision. And I'd like to see more of that. If you come here and commit crimes, go away. That's kind of where I'm at. But yeah. So on that note, we're done for today. I hope y'all had fun. I know I did. It was so much fun. Let's do it again tomorrow. 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. Please do, reminder to you, please remember that we do post videos throughout the day. We've got 3 going up starting in 1 hour. They're already available for channel members. All 3 of them are pretty good videos, each for their own unique reasons, so be sure to give them a look. We are a one-stop shop for all of your LawTube needs. But go have yourselves a great Wednesday. Look forward to seeing you tomorrow. Take care. God bless.